October 21st, in the Department of Consumer Affairs, 1625 North Market Boulevard, Hearing Room 102, Sacramento, California. I would like to call this meeting to order. Agenda item number 2 is the Pledge of Allegiance. Can you please stand with us as we recite the Pledge of Allegiance, and I will ask my fellow board member and veteran John Vertito to lead us in the pledge.
I pledge allegiance to the flag of the United States of America, republic for which it is indivisible.
Thank you. At this time, we're going to move to agenda item number 3, introduction of board members and board staff. I am Samantha James Perez, board president. Will the board members please introduce themselves, starting at my far left?
Good morning. John Deerking, public member.
Good morning. Andrew Moreno, board vice president and public member.
Thank you. At this time, would the executive officer please introduce herself and her staff present?
Thank you, Madam President. I'm Kamika Brown. I'm executive officer. I have with me here Cheryl Anderson, who is supervising nurse executive consultant and also our acting assistant executive officer. Our chief of enforcement is actually on vacation and out of the state today, so we have a representative, Ann Hutchinson, who is over our complaints division. Then we have Jennifer Almanza and Christine Dano.
Thank you. We also have legal counsel present with us today. Legal, would you like to introduce yourselves?
Hi, Rebecca Bond, legal counsel.
Good morning, Laura Friedman, extra legal counsel.
We're grateful to have Laura back with us. She was with us for many years, and we're glad to have you today. I'd like to make an agenda item revision. Agenda item number 8, the 2016 Sunset Oversight Review Report will not be discussed today. This item will be tabled for discussion at the next board meeting. Just another housekeeping matter. We will not be taking corporate breaks today. We will take 1 half-hour lunch, so it'll be a short lunch, but we will not be taking any corporate breaks. If you need a break, that goes for audience members or board members. You can take it on your own. We just ask that you exit the room quietly and quickly as possible. Now I'd like to go over the public comment procedures. During the meeting today, public comment is welcome on any agenda item, as the item is being taken up by the board. Under the Bagley-Keene Open Meeting Act, the board may not take action on issues raised by public comment that are not on the agenda, other to decide whether to schedule the issue for a future meeting. If anyone wishes to address the board, please come forward to the podium. You may give your name and the name of the organization you represent, or you may remain anonymous. It's helpful if you give us your name so we have a record of those who appear, but again, you may remain anonymous. Please note that a person wishing to provide general comment is not required to identify him or herself. However, it is appreciated. In order to allow board sufficient time to conduct its scheduled business, I may limit the time given to each person who wishes to comment. Please make your comments focused and relevant to the applicable agenda item and directed to the board. Again, please, when you're making your comments, it is inappropriate to have any personal attacks on any staff members or board members, but you can voice your concerns generally. Also, when you come up to speak, it's not necessary to repeat the statements or views of a previous speaker. You can just say that you agree, but if you would like to make an original statement, that's allowed as well. Written statements should be summarized and submitted to the board. If I should forget to ask for public comment on an agenda item, it's not because I intend to limit public comment. So please raise your hand and I will recognize you. The board appreciates your cooperation and assistance in meeting its legal mandate. Moving on, that takes us to agenda item number 4, report on and discussion of administrative and enforcement monitor phase 2 results. And our monitor, Mr. Ben Frank, is here. Mr. Frank, would you like to come forward? And I thank you for bringing extra copies of your presentation. They have been distributed to all the board members, and we have reviewed the materials that you submitted to us in advance.
Wonderful, thank you. Good morning, members of the Board of Vocational Nursing and Psychiatric Technicians. Thank you for inviting me to present a summary of the results of the assessment of the board's enforcement program and targeted administrative processes. I hope that you will again find the information helpful to you for ongoing strategic and business planning purposes. I anticipate that my presentation will take about 30 minutes to complete. As with my prior presentation, I begin with a brief summary of the background leading up to the appointment of the Administrative and Enforcement Program Monitor for the board. Additionally, I will provide you with updated information regarding the recent performance and current status of the enforcement program. I will also summarize the recommendations for improvement included in the second report. The presentation concludes with a brief summary of the work that is expected to be completed during the next project phase. I'll be happy to take questions following completion of the presentation. Next slide, please. As discussed in the initial report, the board's complaint intake, screening, investigation, and discipline processes were thrown into disarray by the organizational and workflow changes that were implemented during 2011-12 and 2012-13. These changes included establishing a new non-sworn investigation section and assigning all licensee complaint cases to the new section, including cases involving serious criminal misconduct and significant patient harm that previously had been referred to the Department of Consumer Affairs Division of Investigation. The problems resulting from these changes became apparent to the Department of Consumer Affairs, which did make efforts to encourage the board to utilize the new Consumer Protection Enforcement Initiative guidelines and the Division of Investigation Services. Concurrently, members of this board began developing an awareness of these same problems from reviewing the discipline packages submitted to the board that in many cases were quite old, and recognizing that the licensees were continuing to practice for years without discipline. Additionally, some members were dissatisfied with management's responsiveness to their requests for additional enforcement program information. During September 2014, this board appointed an enforcement task force to assess the board's enforcement and discipline processes. In November 2014, the task force submitted its report to the board. The task force report included 6 recommendations, including a recommendation that the board begin utilizing the CPEI case prioritization guidelines and resume utilizing the Divisions of Investigation Services. The board approved this recommendation along with most of the task force's other recommendations. However, the board continued to assign nearly all licensee complaint cases to the investigation section. Concurrently, reports surfaced during the board's 2014-15 sunset review about the board's organizational and operational problems, and the scope and magnitude of these problems became apparent to the legislature. The board's sunset review hearing was held on March 23, 2015, but the board's responses to the legislators' questions during the hearing did not allay related issues and concerns. Following the sunset review, the Department of Consumer Affairs initiated a review of the board's enforcement program and an investigation of the board's statistical reporting. Concurrently, from March 31 through May 29, 2015, the executive officer, assistant executive officer, the chief of enforcement, the complaint section supervisor, and one of the investigation section's 2 supervisors all separated from the board. Following the separation of the executive officer, the assistant executive officer, and the chief of enforcement, Division of Investigation staff provided assistance to the board with management of the enforcement program, and also began reviewing all of the board's pending investigations to identify cases for immediate reassignment to the Division of Investigation. DCA also provided the board with an acting executive officer. Additionally, a new chief of enforcement and new supervisors for the complaint and investigation sections were hired. Subsequently, Assembly Bill 179 was enacted, requiring that DCA appoint an administrative and enforcement program monitor for the board for a period of up to 2 years to assess the board's enforcement program and specified administrative processes. Reports are required to be submitted to the Legislature on July 1 and November 1, 2016, February 1, 2017, and January 1, 2018. On February 29, 2016, DCA awarded a contract to Benjamin Frank LLC to provide the monitor services. An initial assessment of the enforcement program was completed during March and April. The initial report documenting results of the initial assessment was presented to this governing board on June 20, 2016, and submitted to the Legislature on July 1, 2016. Additional research, interviews, and analyses of the board's enforcement program and targeted administrative processes were completed during June, July, and August. The second report documents results of these supplemental assessments. Additional interviews, research, and analyses in a few remaining areas are expected to be completed during the next project phase. Turnaround of the board's enforcement program. Corrective measures taken during the past year have contained the problems that accumulated in the prior years and set into place a foundation for building a sustainable, effective, and efficient enforcement program. Improvements made during the past year include a complete restructuring of the license applicant arrest conviction report process, a restructuring of the case intake and screening process, significant increases in the number of completed licensee arrest conviction report and licensee complaint investigations, significant reductions in the number of pending investigations and in the average age of the pending investigations, significant increases in the number of cases referred to the Attorney General and the number of discipline cases completed, significant reductions in the average elapsed time to file pleadings and complete disciplinary actions, and significant reductions in the number of pending discipline cases and the average age of the pending discipline cases. The bar graphs below show that the restructuring of the licensed applicant arrest conviction report process significantly reduced the number of cases referred to enforcement by about 3,000 cases per year. Next slide, please. As shown by the bar graphs on this slide, during 2014-15, primarily during the last several months of the year following the board's sunset review hearing, more than 100 enforcement cases were reassigned to the Division of Investigation. Subsequently, during 2015-16, about 370 enforcement cases were referred to the Division of Investigation. That includes both reassigned aged cases that had languished in the investigation section and newly received cases involving serious criminal misconduct or significant patient harm. Next slide. The bar graphs on this slide show during 2015-16, significantly more licensee arrest conviction reports and licensee complaint investigations were completed. There were also significant reductions in the average elapsed time to complete both license applicant and licensee arrest conviction report investigations. Next slide. As shown by the bar graph on this slide, during 2015-16, there were significant reductions in the number of pending license applicant arrest conviction report, licensee arrest conviction report, and licensee complaint investigations. The total number of pending enforcement investigations decreased by more than 35%. Concurrently, the average age of pending licensee complaint investigations decreased from about 17 months as of June 30th, 2015 to about 13 months as of June 30th, 2016. However, the total number of pending licensee complaint cases is still quite large, and the 13-month average age of these pending cases is still quite old. Next slide, please. As shown by the bar graphs on this slide, the number of cases referred to the Attorney General's office and the number of discipline cases completed both increased significantly during 2015-16. Concurrently, the average elapsed time to file pleadings and complete disciplinary actions decreased. The average elapsed time from case receipt to completion of the discipline process, commonly referred to as PM4, decreased to about 2.5 years for cases completed during the second half of 2015-16 from about 3 years for cases completed during 2014-15. However, the 2.5-year average time frame required to complete these cases is still quite long. Finally, as shown by the bar graphs on this slide, during 2015-16, there were significant decreases in the number of pending discipline cases and in the average age of the board's pending discipline cases. However, the total number of pending discipline cases is still very large, and many of these cases are quite old. Current status of the enforcement program. Notwithstanding all of the improvements already made, there are still very large backlogs of aged cases in several key areas and continuing problems with the completeness, consistency, and quality of the board's enforcement program data. Additionally, the amount of calendar time needed to complete investigations and impose discipline remains much too long, and during the past several months, there has been very little change in the number of pending investigations. For example, as of late September, there were still about 400 pending non-sworn investigation cases, the same number as were pending as of the end of June, and about 160 of these cases were not yet assigned to an investigator. If all of these cases were assigned to the investigation section's investigators, each investigator would have about 60 to 70 assigned cases, which is not a manageable caseload. The board's current case backlogs and the extended time frame still needed to complete investigations and impose discipline provide a context for better understanding the scope and magnitude of the problems inherited by the board's current management team. Separately, there also appears to be a high level of noncompliance with the board's continuing education requirements and only limited enforcement of licensee compliance with these requirements. Additionally, as a result of the settlement of much larger numbers of pending discipline cases, the board's probationer population recently increased significantly. Associated increases in probationer monitoring and subsequent discipline workloads are expected to persist for the next several years. Additional changes and further improvements to the Enforcement Division's organizational structure, workforce allocations, and business processes are needed to better address current and emerging workload demands and business process deficiencies and improvement needs. Next slide. Recommendations for improvement. We developed 2 recommendations for further improving the handling of licensed applicant arrest conviction report cases. Recommendation 4-1 involves critically reviewing and overhauling item number 9 of the Record of Convictions form to make it more readable and understandable and reduce the frequency that licensed applicants misreport or overreport prior convictions. Recommendation 4-2 involves developing and implementing procedures to enable case intake staff to exercise judgment in determining whether to request records from law enforcement agencies and the courts for licensed applicant cases that are based on minor criminal offenses that occurred in the distant past, and screen the cases to identify and close cases that do not require desk investigation. Next slide. We developed 2 recommendations for improving compliance with the board's continuing education requirements. Recommendation 4-3 involves overhauling and significantly expanding the continuing education compliance audit program. This would involve issuing an initial standard form 30-day audit letter to a sample of at least 5% of renewing licensees in conjunction with issuing their renewal notification. Then, if the licensee is non-responsive to the initial request, promptly issuing a second and final request. If the licensee is still non-responsive to that request or confirms that they did not complete the required CE, then promptly refer the case to enforcement for issuance of a citation. Finally, streamline the certificate of completion review process by limiting reviews of the documents in cases that appear to show full compliance with the board's CE requirements, and assess the feasibility of imaging CE-related document submissions and enabling submission of the documents electronically. We developed 4 recommendations for further improving the handling of licensee arrest conviction report cases. Recommendation 4-5 again involves reviewing and overhauling item number 9 of the current Record of Convictions form to make it more readable and understandable and reduce the frequency that, in this case, licensees misreport or overreport prior convictions. Also, develop programming for online renewals that requires confirmation by the licensee when the yes box is checked, or to prevent further processing of the renewal application until other fields providing additional information about the self-reported conviction are provided. Recommendations 4-6 and 4-7 involve working collaboratively with the Attorney General's office to identify ways to increase the utilization of the current Fast Track pilot program and expand the Fast Track pilot program to other geographic regions of the state. Recommendation 4-8 involves developing and proposing legislation to specifically provide this board with the authority to delegate approval of default decisions to the executive officer. I would point out I am not recommending that the board seek legislation to enable delegation of the board's authority to approve stipulated settlements other than those involving license surrender. Next slide. We developed 3 recommendations for further improving the intake and screening of licensee complaint cases and the capture and reporting of related enforcement program management information. Recommendation 4-9 involves developing and implementing a structured, sustainable business process for screening licensee complaints to identify cases that do not require field investigation, and then assign these cases to staff that specialize in completing desk investigations of those particular types of cases. Recommendation 4-10 involves developing and implementing procedures to enable case intake and screening staff to review and not open cases involving discipline by another state or agency, or alternatively to screen and close those types of cases that do not require completion of a desk investigation. Additionally, notify the agencies currently providing courtesy notices to stop doing so in cases where they routinely post the same information on a professional licensing database, such as nurses, or the information is otherwise available from Breeze. Recommendation 4-11 involves continuing to refine licensee complaint case coding procedures and practices and provide training to staff to further improve the consistency and completeness of licensee complaint records and the tracking and reporting of related enforcement program information. The second report provides 13 recommendations for Enforcement Division organizational and staffing improvements. This includes recommendations to continue identifying and assigning licensee complaint cases to the complaint section for desk investigation, pending establishment of a separate business unit that specializes in completing desk investigations of those types of cases. Continue utilizing temporary help to augment probation unit staffing for the next 2 or 3 years and establish a new probation section. Redirect vacant investigation section positions as case backlogs and new case assignments continue to decrease. Redirect and consolidate resources to enable additional screening and completion of desk investigations and support expansion of the CE audit program. Additionally, the Board's Chief of Enforcement should maintain open lines of communication and meet periodically with counterparts of the Division of Investigation and the Attorney General to develop strategies to further reduce case backlogs and the amount of time needed to complete investigations and impose discipline. Finally, needs exist to bolster investigator case review and performance review processes and the training provided to the investigators. I think we're behind a few on the, there we go. This slide depicts a proposed future state organizational structure for the Enforcement Division. With this proposed organizational structure, the complaints section would continue to be responsible for case intake and screening and for handling all license applicant and licensee arrest conviction report cases, cases involving discipline by another state or agency, continuing education cases, and citation issuance and collection. A new desk investigation and field investigation case review section would be established to focus exclusively on completing desk investigations of licensee complaints. Additionally, licensee complaints would continue to be assigned to the Department of Consumer Affairs Division of Investigation for sworn investigation and to the investigation section for non-sworn field investigation. Those completed investigations would be submitted to this same section for review of those completed investigations, determination of needs for supplemental investigation, determination of needs for obtaining outside expert opinions, and for performance of what many other boards and bureaus refer to as the discipline review function. In fact, some of the other boards, DCA's other boards and bureaus, have a full unit that's just referred to as the discipline review unit. So these are the staff that review the completed field investigations and determine whether the case should be referred for issuance as a citation or referral to the AG for discipline. The field investigations unit would focus on, or with the current investigation section, would continue to focus on completing field reviews of licensee complaint investigations that are not referred to the Department of Consumer Affairs Division of Investigation. And then the discipline section would be split into two sections, with the discipline section focusing on case intake and management, and perform, including the processes used to collect, compile, and report enforcement program-related management information and assist Additionally, also, on an annual basis, the board should develop goals for each of the key workload and performance measures listed on the report and include those goals in all of the quarterly reports. Needs also exist to bolster the training provided to the members. Whoop, where are we? We got lost somewhere. Ah, there we go. Okay. Needs also exist to bolster the training provided to the members of this board and to address long-standing systemic deficiencies with the board's oversight of the enforcement program. New board members should be consistently provided with substantive new board member orientations and related training and reference materials specific to the board's enforcement program and other board programs and services provided as appropriate. The training should be structured so that it complements DCA's BMOT training and helps new members to better understand and fulfill their program oversight, strategic planning, policy development, executive officer performance evaluation, and other responsibilities. The board should consider requesting that a representative of DCA participate in these orientations to help integrate the board's orientation training with DCA's BMOT training, particularly with respect to helping new members understand and fulfill their oversight responsibilities. Finally, the reference materials contained in the two large binders should be overhauled to make the information more useful communicating in the board as needed to support fulfillment of the board's strategic planning, policy development, executive officer performance evaluation, and other responsibilities. The board should consider developing similar charters for other board committees where appropriate. Finally, briefings should be provided to enforcement committee members, initially on at least a quarterly basis, to provide information regarding case intake, investigation, and discipline workloads, backlogs, and performance improvement initiatives underway and planned, policy matters, and other information as determined by the committee. Next steps. During the next 2 months, we expect to complete additional targeted assessments of the following 3 areas specifically referenced in A. Complete of Healthcare Services and the California Department of Public Health to gather additional information related to their enforcement case referrals and to support assessment of the board's cooperation in enforcing laws and regulations regarding its licensees. A primary focus of Phase 3 is expected to involve monitoring the board's implementation of the previously presented recommendations for improvements. We also plan to complete targeted verifications of key data for the 6-month period for January 1 through June 30th, 2016, and collect, compile, summarize, and analyze additional enforcement program data for the 3-month period from July 1 through September 30, 2016. Finally, we'll prepare a Phase 3 summary report and a work plan and schedule for completing Phase 4. In concluding, I would like to take this opportunity to express my appreciation to the board's Chief of Enforcement, Gina Bayless, and her staff for all of their cooperation and assistance in completing the assessment of the board's enforcement program. In particular, I would like to single out Matthew McLean and Elizabeth King for their responsiveness and assistance in providing CAS and BREEZE data, and the manager of the complaint section, Ann Hutchinson, and the complaint section's 2 leads, Tricia Bergen and Laura Sherman, and the manager of the discipline section, Rocio Lamas. Additionally, the entire enforcement division should be recognized for the many performance improvements that they have achieved during the past year. I would also like to thank the members of this board for the information and oftentimes quite candid input provided to me during our recent interviews. This information was especially helpful in formulating recommendations for improvement involving board member training and the board's committees. Finally, I would like to thank the Department of Consumer Affairs for the cooperation and assistance provided by DCA staff, including staff within the Division of Investigation, the Division of Legal Affairs, the Office of Human Resources, and the Office of Information Services. Thank you.
Thank you for your report, Mr. Franks. I agree with you. I think our enforcement division is doing a great job, and I thank you for recognizing them. I would be remiss if I didn't also acknowledge the foundation that was set for them by Stephanie Whitley, and I see her in our audience today, so I just wanted to say thank you to Stephanie. I have a couple questions, and on the recommendations. One thing, though, I read it over and over, and I'm not quite understanding it. I'm sure you can help me figure it out. On the executive summary, page 2 of 3, it's talking about the CE requirements, and it says that it appears that at least 10 to 15% of licensees complete very little or no continuing education. But how can that be measured? 'Cause since we don't survey all of them, can you help me understand that?
Sure. So the board has been doing for some number of years anywhere from typically from the available data that we have from 600 to about 1,600 audits of licensee compliance, of continuing education requirements. And of those, a significant portion either just ignore the department's requests that they provide information regarding their compliance with CE requirements, ignore repeated requests, or they provide documentation that shows that they completed the CE after the audit period. So in other words, they got the audit notice,
Right.
they went online, they completed the CE, they submit that, hoping it'll help, and they say, that's fine for the next audit period, but you still owe us 30 hours for the prior period. So the staff that's performing the audit, they refer those cases to the enforcement division. The enforcement division prepares a citation, and in this citation, they specifically document that the person either did not respond to the board's request, in other words, they failed to cooperate, and here's your $500 fine or $750 fine, or thank you very much for cooperating, but you didn't comply at all with the requirements, and so here's your $500 fine, and it would be $750 if you didn't cooperate. So I actually read through dozens and dozens of those citations, and it's clearly evident that there are, and the number would be at least 10 to 15%, and some documentation suggests up to 20% of the licensees don't complete any CE for at least that 2-year audit period.
So it's basically the pattern that you've seen.
That's
from
the pattern.
sample that you've had.
It's a zero. There's a few that will have completed some CE, but mostly it appears to be it's just a zero. So, and the number of citations that were issued on that basis suggests that based on, as compared to the total number of audits that the data suggests had been completed, indicates that at least 10 to 15% of the licensees complete 0 CE.
So it's extrapolating that average from.
And that's over, in your own sunset review reports, that's been, the information that's presented in the sunset review says, oh, we had 80% compliance. But the other flip side of that is you have 20% non-compliant.
Gotcha.
So,
And then, yeah, I just wanted to go over a couple recommendations. I'm glad that we have staff here. I just have a couple questions about things that may already be being done at the board.
Sure.
I agree with your information, and I'm wondering if some of this stuff is already being done. So the recommendations 411, 51, and 55 seem just complete, just very accurate, easily to be accepted. I'm wondering and actually suggesting V8, V10, V12, 6.2, so VI2, and 7, VII2 I'm thinking that these could be delegated to our enforcement committee to monitor. We have an enforcement committee now. So I know the committee members are here. And for 7.1, so V11, VII1, I also was looking at that and thinking about it, that could also be delegated to the executive committee. Might be something that could be done. Now, I'm going to go through a couple, and I promise to be as quick as possible. 4.1, there does definitely need to be some overhaul of number 9 on the current record of conviction. I'm a little concerned that it might be premature because we need to review our licensing processes, and that form affects both licensing and enforcement. So I'm wondering if that would be best to be not rejected, but delayed until maybe we oversee the licensing division.
I think in the front end of the second report,
Sure.
I gave you a template. It lists all the recommendations, and it has a calendar there. The priorities haven't been, well, one, the recommendations haven't been accepted. 2, priorities haven't been set on those recommendations. And 3, there's no timeline for completing those. There's no sequencing, hasn't been done.
Gotcha.
I really think that is not my responsibility to do that for you. I'm happy to collaborate with you in a process to build out, if you will, an implementation plan for those recommendations that you want to move forward with. And then, but I really think the board and board staff have to have ownership for the timing and sequencing of those things, considering the totality of the board's needs and circumstances.
I agree with
So
you. That's not your job.
that would be that would be the next. I had actually hoped that would have been able to be presented as part of this report to
Okay.
you, but that didn't occur, and so that would be a logical next step for you to move forward with.
And then the, yeah, on this one, or, yeah, this, okay, yeah, go ahead, John.
I just, thank you, Madam Chair. Mr. Frank, just to be clear, are you stating that if nurses' application for relicensure do not complete the 30 licenses?
My understanding of the way the renewal process works is that they simply self-certify in their renewal application that they completed the CE. And then historically what has happened is licensing program staff have gone to the completed license renewal files some months later, like 6 months or even longer later, and selected files for which they then request that the licensee provide certificates of completion for that renewal cycle. And that's when the failure is identified. So basically and that's why those cases get classified as internal fraud cases, which is what triggered this whole analysis, because we had these cases called internal fraud, because the licensee, if you will, fraudulently certified on their renewal application that they had completed CE when in fact they had not. But we don't find out about it until an extended period of time after the renewal occurs. So what I'm suggesting in the recommendations is that, one, don't wait, because you even run into address change problems where the mail doesn't get delivered if you don't submit the audit request for 6 months or more later. So what I'm suggesting is when you mail out that renewal notice, you got a good address then, because the licensee wants that renewal. Right then, submit the request right with that same mail, the request that they provide the documentation for their certificates of completion for their CE. That makes it much more real time. And then you follow up, and if they haven't, many of them will just say, I didn't do it, or they just don't respond, and then you're able to just follow through with the enforcement.
Does that include, since we now have the option to renew licenses via Breeze, would that be then requiring electronic submission of the CEU certificates? That was one of your
That's
options.
another, yeah, that was another option. And so historically what the problem has been, if the board for all of its 130,000 licensees collected certificates of completion with every renewal, it'd be overwhelmed and buried in paperwork. So even with online, you're going to have some number of folks that are going to continue to use the manual, the paper-based processes. So you know, and even if you get all of that information, a lot of people don't have the technology to, say, scan and upload certificates of completion as part of their renewal application. So I think, and then what do? We would have to then look at all of that document if all those were submitted. So I think the idea of auditing a sample is a more efficient process, and but I do support the idea of enabling electronic submission of the certificates of completion for those audit cases, or imaging the documents as they flow in on a flow basis so that they can be handled and retained more efficiently.
And that also is part of 4.4?
And that was all,
is
I think, it's all
related
part of the same
submission.
recommendation, but
Yeah.
I can't tell you the number of it off the
Yeah,
top
no,
of my
but I'm
head.
just, I
okay?
see it here.
But,
it's my
yeah, that
belief,
4.4 was the imaging
Yeah.
and submission of the documents electronically, exactly.
and maybe staff could either confirm or deny. I believe that we're already in the process of doing this, that we've received can you explain? We've received a,
Sure. So just for the board's reference, this was a part of our overall digital migration that we were looking at. And so with this, we had originally submitted a BCP, and it was determined that it would be better to actually have this in a contract. And so that was actually done. And so now we are waiting on the statement of work. So this is a part of an overall to have the entire board go to a paperless. So yes, it does include CE.
so it's already in the works. And then there's a couple recommendations about the fast track program, which, yes, you're correct, was a task force recommendation, and I was one half of that task force. There has been some developments, though, with this. It's 4.6, 4.7, everything to do with the fast track. I know we have been participating and in contact with Linda Schneider, correct me if I'm saying the wrong name, since March 2015, and also it's my understanding that they're coming to our November board meeting. Is that true?
Yes, so they, for the fast track, they will actually, Brett Kingsbury would be here, who is, reports to Linda to talk about that and to talk about one of the innovations they were looking to do was we have fast track in San Diego, and we are setting up a dedicated fast track desk, but we are actually looking at how we can expand that to our LA area. So yeah, they will be coming in November.
So we agree with you, the recommendation, and it's already been
Right.
done.
You know, the issue is that very few cases to this point have been accepted for the fast track program. So something is not quite working the way it could. And when you compare the rate of acceptance of this board's cases with information that the AG provided about the numbers of cases accepted for BRN, which was the other kind of pilot agency, they're experiencing appears to be much higher rates of acceptance.
Really?
So something's not working correctly with the process, and we haven't resolved what that is to this point.
And I know Gina's not here, but maybe Ann could even confirm. I know Gina's been speaking with Linda, and the fast track is only in the San Diego site, I believe, right now, and talking about getting it expanded. And at the November meeting, I'm sure we'll be asking those questions of Linda Schneider. So I agree with you, and in fact, we're already working on it. Just one. As far as 4.8, providing the governing board with authority to delegate approval of default decisions to executive officer, that was a task force recommendation, and that's already in the works, correct? And legal may know more about that, because I know there's some sort of legislative thing that has to happen.
Yeah, you have already adopted that at your previous meeting, so you've adopted.
Okay.
So then that is something that when we review sunset, you guys will have the ability to approve that. We are including that in our sunset report at the November meeting.
Great. There was one thing, and I'm not sure who I need to direct my question to, because it's a labor issue. 5.3. Or maybe not 5.3. Which was the one that I forgot? There was something about reclassifying or rearranging some staff. And I know that that's something that we'd love to do, but I know there's some labor negotiations involved in that. I'll just move on. And just a couple more as I go down here. We have a new some of these are task force. Oh, open lines 5-9. Chief of Enforcement continue to maintain open lines of communication, meet periodically with counterparts at the Division of Investigation. When I spoke with Gina, she said that this is an ongoing thing. I don't see any members of DOI here that can confirm that. But the information I got was that it is ongoing, and the 510 is also ongoing, and 511 was implemented in October 2015, I believe. So we have a lot of the same ideas, Mr. Frank. I'm almost at the end here. Just a couple more. The 514, assign responsibilities and due dates for completing annual performance reviews.
I'm sorry, which one?
I'm sorry, 514, V14. I believe that there was an audit finding with a completion date that this is already going to be completed in December 2016 in 2 months. Can someone confirm that for me?
Yes, so all of this is, again, it's a board-wide initiative when I came on, and so this was an internal audit finding from our March audit, and so we actually have that every manager has to complete both an individual development plan. So even though those are traditionally done on your anniversary date, we are shoring these up because staff haven't had those since 2014. So they are all required to do an individual development plan, as well as then update with actual robust training that we've been doing. So that's all has to be done by the end of the year.
And then, as you mentioned, there was sort of a time lag. We had some new staff come on, and
Right.
there was an old survey that was out there. So 7-1, 7-2, 7-3, I believe 7-1, this information had more to do with the previous administration, and I know that we've made significant strides to improve this sort of training, and I believe that 7-2 and 7-3 have already been completed. The Enforcement Committee is already working on its roles and responsibilities, and they are meeting. So I think that, yes, we agree with you, and some action has already been taken towards those goals. So I guess I would just reiterate what I was thinking, that some of the stuff we've already worked on, and for my fellow board members, I believe 411, 5.1, and 5.5 absolutely on target. I think 5.8, 5.10, 5.12, 6.2, and 7.2 could be delegated to the Enforcement Committee, and I believe 7.1 could be delegated to the Executive Committee. Any board member questions?
Can you list those? Can you list those again for the enforcement and exec committee?
Sure. So just, this is what I wanted to throw out there, that with our new Enforcement Committee that's very robust, I believe 5.8, 5.10, 5.12, 6.2, and 7.2 could be delegated to the Enforcement Committee. So we still agree with your recommendation, and that could be handled very efficiently by our Enforcement Committee. And I believe, Andrew, you and I and Dr. Brown, as the Executive Committee, could, 7.1 could be delegated to us. The other ones that I think we are not already working on, and I completely agree with you, would be 4.11, 5.1, and 5.5. Now, I see board members kind of looking, maybe some questions. Any questions for Mr. Frank?
I have one. In your report, you mentioned taking investigator vacancies and redirecting to other positions. That then may become an issue with not only the union factor, because there's some agreements within the classifications, and then not only that, how are you redirecting them? Are you just redirecting the job? Are you redirecting the title? Are you renaming the title? then also becomes in regards to their job duties. Are you changing their duties? Are you adding more duties? Because then it becomes a workload issue.
Right. On the investigation section, there's various ways and strategies that can be used for redirecting vacant positions to address other enforcement program or broader board business needs. So that would be kind of my first response to it. There's not just one way to redirect positions. Number two, historically, over the last couple of years, the investigation section has completed about 400 investigations a year. Under the current processes where you're using the Division of Investigation, and also if you were to, as you are currently doing enhanced screening of cases before referring them to the Division of Investigation, or completing completing the investigations using desk investigation processes as opposed to field investigation processes, there's many fewer than 400 cases being referred to the Division of Investigation. So as those, currently, as I mentioned during my presentation, there's 400 cases pending there. There's always going to be some significant number of pending cases, but as that backlog goes down, there certainly should not be a need to continue to have the same number of staff in that section as there have been historically. And what I'm suggesting from a workload, workflow, workforce, and performance management standpoint is that it would be much better, as to some extent you currently do, to have specialized units for handling different types of investigations. So for example, the complaint section does investigations of all of the licensee arrest conviction reports. And the Division of Investigation performs investigations of licensee cases, complaint cases involving serious criminal conduct and significant patient harm. That leaves some number of other cases that require, licensee complaint cases that require either a desk investigation or a field investigation. One of the things that's sort of special about your licensee complaint workload is that a significant portion of the complaints are reports where their employer mandated reports, where the employer has already imposed some kind of sanction or discipline on the licensee. In that regard, it's somewhat like in some respects, it's like a subsequent arrest report or a subsequent conviction report where a local law enforcement agency adjudicated a case against the licensee, or a case involving discipline by another state or agency where they disciplined the licensee. So this is a case where the employer already disciplined the licensee, and they're referring these cases to you for possible action. And in many of those cases, they don't require a field investigation. We simply need to collect their records that were used to support their disciplinary action. And so and what I'm suggesting is that many of those types of cases, and many of which involve like workplace practices or other situations at the employer, could be handled by an investigations unit that specializes in completing desk investigations of those types of cases, rather than, and then the investigation section would focus on completing field investigations of licensee complaint cases.
That wasn't my question.
Okay.
My question was, you're saying, in your report, you're saying you're taking investigator vacancies and redirecting to other positions. So you're having one person that does one job, redirecting them to do another job. That now becomes an issue because you're having them do a different classification's work.
Not necessarily. Already you use different classifications to use different types of work. So it depends on where you're assigning the work. not the classification. What we're trying to do is align the workforce and the numbers of positions and the classifications of those positions to the different categories of work that need to be performed.
In other words,
So right now, they're not aligned because there's more positions that are established for doing a certain type of work, and there isn't the same number of cases of that type of work, significantly because many of those cases are now referred to the Division of Investigation. They were being all referred to the investigation section.
what you're recommending is swiping the positions and reclassifying the positions.
Where it's appropriate to do so, yes. Yes, because you wouldn't continue to need, you wouldn't continue to need the same number of special investigators to do half the workload that they have historically done.
So it would be vacant, totally vacant positions, nobody in them currently.
There already are vacant positions in that section. So I'm not suggesting redirecting or filled positions. I'm saying as position vacancies occur, you have the option of reclassifying and redirecting those positions to address board needs in either the enforcement program or in other areas of the board.
They do to an extent,
Right.
but there also becomes issues because you have contractual issues with different bargaining units.
I understand. And that's a process that the board would need to work through to implement that recommendation.
And that was my question about it is, not necessarily that we disagree with the staff need to be rearranged, but how that would affect the negotiated agreements, labor agreements, which is something we have to honor. I know that there's one vacant position. Did you have anything?
No, we have one special investigator position that's posted, and then we have the we have an acting. So we have currently two. We have one supervising special investigator, and we have an acting that is filling that vacant one. So on paper, by HR standards, we technically don't have any vacancies, but we do have an acting currently filling that supervising special investigator role.
Needs to be some investigation of how this would affect the labor agreement. Dr. Basti Martinez?
Just a little follow-up here. I mean, clearly, we're talking about how do we move work forward and how do we cut the backlog. Given the recommendation, it sounds on paper wonderful. The concern becomes while we are spending the time going through the necessary process to reclassify, which can be, doesn't have to be, but it can be time consuming. What's the plan B or the plan C or another recommendation so we keep things moving?
Well, you have an option, I suppose, of filling the positions in their current classifications, but there is a timeline associated with filling those positions, and then there's an even longer timeline associated with training those positions. I think under any reasonable scenario, your backlog has gone away before that process is completed. So it sort of doesn't argue very well that that is a viable option. Why are you going to fill positions that by the time they're trained, you no longer would need? So the path that has been pursued to this point has been to, as those positions become vacant, to start looking at alternative approaches for reclassifying and redirecting those positions as needed to better address your needs. And in any event, I would still argue that it would be, regardless of the position classifications that are used, from a workload, workflow, performance, and workforce management process, it would be beneficial for this board to have separate units set up for doing desk investigations of licensee complaints and field investigations of licensee complaints, because otherwise it becomes very difficult to manage the workforce and to manage the performance completion of those investigations.
Mr. Deerking, do you have a question?
Yes, I just wanted to kind of follow up on the comments by members Basti, Martinez, and Ms. Undozo. And it does appear to me that we have some sensitive MOU and bargaining unit issues, especially relating to working out of class, as was mentioned. For example, in recommendation 4-2, develop and implement procedures to enable case intake staff to exercise judgment. Well, if they're not doing that now, then wouldn't we have to take a look at the job description to make sure that these our staff are not working out of class?
I don't think in the case of that particular, or do you want to add, was that a question for me? Go ahead.
Oh, either.
Yeah.
Please.
So the example here is that we're talking about license applicant cases.
Right.
Where they're required to report any arrest or conviction meeting certain requirements over their entire lifespan. So they get in cases where they had like drinking underage or presenting a false ID or petty theft that's 20 or 30-year-old case. And the staff is actually who came to me with that recommendation. The performance said, do you know how complicated it is for me to go out to law enforcement agencies and the courts and get their records for a 30-year-old case involving some minor criminal offense that occurred 20 years ago or 30 years ago? Because the law enforcement and the courts don't have the records anymore. And they're saying, you know, really, why am I spending the time doing that? And, you know, could I make the decision under certain guidelines provided by management not to request those records in those cases, or to look, and in other cases, I can look at it and say, this case doesn't need any more investigation. So that's doable within their current classification. It's not complex, it's not analytical, it's not research, it's just looking at it and making a judgment decision. And all of those cases would still be referred to the supervisor for review, filing, closing, or a lead. And so it's just a matter of whether, you know, what the current practice was. We request records for all of them, we wait until we get the records, and then we refer it to an analyst to investigate it, to do a desk investigation. We're like, why do all that when you can resolve it right up front?
Well, it just seems to me, I mean, just as a follow-up, that using independent judgment would supplant or obviate the need for further review, right? So we wouldn't necessarily refer to a supervisor for a final decision?
The closures would still probably get reviewed by either a lead or a supervisor that they had done that. What you're doing is eliminating the referral of a case for a desk investigation and eliminating, in this case, the need to even go get records for a case that isn't going to lead to any kind of a denial of licensure anyways.
Well, I understand that.
You can make a note in the record, but you don't have to go get the records.
And in point of fact, with many licensees, one of the issues is cooperation and compliance. So we already consider that, is my understanding.
So
I just wanted to pause a moment because we do have a legal comment.
Yeah, so I think what I hear the board members being concerned with are issues that pertain to civil service laws, civil service classifications, out-of-class issues, bargaining unit issues, classification of, obviously, the employees and what those duties are. And those are very legitimate concerns that I think if the board is interested in pursuing, I think what you could do is look at those and then kind of have work with DCA, because it would probably be the HR office who would help you resolve those issues to determine whether or not there's any existing laws that would prohibit adopting the recommendations exactly as they're written. So I come to this particular piece with an admin background. This has nothing to do with my experience with the board, but I work in our office on admin matters. And so we do deal with like out-of-class complaints and things like that, or grievances. And so I think I'm sensitive to what I hear the board members saying. And my suggestion would be that if the board pursues the recommendation, that it sort of recognize that in implementing that recommendation, you're going to have to work within the existing structure of state employment in order to accomplish that.
Thank you for that clarification, Laura. Mr. Vertito?
Madam Chair, I'd like to make a motion.
Yes, please.
I move that the Board of Vocational Nursing, the full review of the report be moved to the November meeting due to the timing of the report was received. Additionally, I request that current data be included in the, to ensure accuracy of the report as presented. We got these reports less than a week ago, and even though we've read them, I have to read mine multiple times in order to understand all the data coming in, because it's a lot of information coming at us, and working a regular job and trying to read these, I did not get enough to really digest all the information. I'd like some additional time to go over this, especially since it's going to be far-reaching impacts to the board.
Of course.
So,
Now, I know we have, I'm not sure that Mr. Frank is available to come back in November.
I don't know what date your November meeting is.
Oh, no.
Oh.
You wouldn't, so, I'm sorry. So we're saying you would not have to be, because you've already presented, we could just
Okay.
discuss it later. I hear what you're saying, Mr. Vertito. I also know we have a very full agenda in November, so I'm wondering what other board members think.
Well, I have some follow-up questions, too,
Yes.
To the point. If I could, and I'll try to be quick, on the issue of continuing education non-compliance, the code already specifies that the license should be placed on inactive status, correct? Mr. Frank?
I'm sorry, I don't understand the question.
Okay.
When
You're
inactive
recommending,
status when?
you indicated that the current audit penetration is between 600 and 1,600 licensees, correct? Which is about 2%?
It's like less than 2% of the licensees are audited per year.
And then recommendation 4-3, you're recommending a sampling of at least 5% of the renewing licensees.
Correct.
How did you arrive at the 5%? Was that a professional judgment, or did you use a statistically derived formula?
No, I didn't do a statistically derived formula. Given the level of non-compliance and the fact that that those that are not complying, the data that I have available shows they're doing 0 CE. I thought it would be prudent for the board to increase the number of audits done and then monitor it from that point forward and get more and better data. And I think looking at the number of additional staff that would be needed and the available resources, that could reasonably be done within the board's existing capabilities. So kind of, we just sort of use that as a starting point.
So by my rough math, it would be somewhere between 3,200 and 4,000 licensees that you would be auditing.
I think you renew about 60,000 a year or so, active. So 5%, it would be 5% of that number, and they would be selected randomly, and you'd have a better, more structured process that you could then get better metrics on and make your decisions regarding what to do from that point forward.
Okay, thank you. If I can ask a couple other.
Yeah, give me just 1 second. As a matter of procedure, there was a motion put forth. So before we take more, which we will take more board member questions, we just have to see if there's a second for Mr. Vertito's motion.
I second.
Madam Chair? I second the motion.
Okay, thank you. So as a matter of procedure, we now have a motion and a second. Mr. Deerking, please continue.
Oh,
with your
sure.
questions.
I just wanted to go through the intake scenario, can you tell me how coding impacts how staff actually works the case?
I'm sorry, I couldn't quite hear you.
The coding
How-
with intake staff, how does the coding affect how staff actually works a case?
I don't know that the coding affects so much how the case is worked, but it does affect your management information. So for example, during just in the recent months, the data I was looking at, cases that involve arrest conviction reports may come in as a subsequent arrest report from the Department of Justice, may come in as a self-reported arrest conviction report from a licensee that's renewing their license, may come in from a law enforcement agency.
Right.
And some of those cases, they're all arrest conviction reports. They all get handled the same way. They all currently, under current practice, the idea is to have all of those cases, almost all of those cases, handled by the complaint section. But the problem is some of them get coded as licensee complaints and some get coded as arrest conviction reports. And so then you end up showing more complaints, if you will, and less arrest conviction reports, and then that distorts all your management information about how the performance, the workload and workflows and performance of each of those different workflows. And I'm suggesting to you, as you've seen, heard me, at the risk of repeating myself, it would be much better from a management standpoint to distinguish these different workflows and monitor each of them independently, whether it's arrest conviction reports or licensee complaints or continuing education,
Right.
as opposed to having all of that commingled as it has been in the past.
Okay, and the reason I'm asking that, Mr. Frank, is you're requesting basically a new set of reporting data, new data points for these different performance measures, right? And at the same time, the Department of Consumer Affairs already has its own performance measures, as you're aware. And the board receives a report on those measures. What will this reporting do that the existing structure framework that the DCA reports, what will this report do that the Department of Consumer Affairs reports do not?
This reporting is supplemental to the Department of Consumer Affairs reporting. The Department of Consumer Affairs reporting is set up as kind of a generic reporting across all the different boards and bureaus. And I think there's, 35 to 40 different boards and bureaus that have to report. This is supplemental, specific to the nature of the work and the workflows and performance of this particular board, to supplement that, to give you better information that you can use to oversee and manage this board's enforcement program. I would not necessarily recommend transferring exactly that same template to some other board or bureau, okay? And it is also something, maybe sometime in the future, you don't need it, and I allude to that in this report, that the amount of supplemental reporting, the frequency of that reporting, and so on, should vary with your needs. But right now, you continue to have significant backlogs and significant performance problems. And I'm suggesting that this reporting be utilized to help you oversee and manage that program, the enforcement program here, until those problems diminish.
Right, and I understand that, you know, part of your role is to validate the board's internal processes, correct?
Correct.
Which you've done very well here in your report. Did you also engage staff in the report?
Yes, I was very involved, working collaboratively with specifically the Chief of Enforcement and a number of the Enforcement Division staff in completing all of these analyses throughout the process.
Okay. And the enabling legislation, by my reading, would intend to include also our licensing division.
I don't agree with that.
Okay, so, because
At
your
least not
report
in the
is,
broad sense. It only with respect to those targeted administrative processes.
And the reason I'm saying that, of course, is your report is covering exclusively, virtually all enforcement aspects.
Yes, a straight reading of the legislation is that it only covers certain targeted administrative processes. In fact, even the use of the term administrative and enforcement monitor delimits what the monitor is doing. It's not a Board of Vocational Nursing and Psychiatric Technicians monitor generically, and then the legislation enumerating, here's the stuff we want you to do at licensing, education, and enforcement, and admin. It very specifically delimits the monitor to administrative and enforcement, and then delineates within that, here's the administrative things we would want you to focus on, and here's the enforcement and discipline things.
Yes, I understand your interpretation. And I've gone through all of your recommendations, and it seems we do have some issues with some of them. Let me ask you this, Mr. Frank. What five or six would you consider to be the most crucial out of your recommendations?
That's a great question. Number one, to address the backlogs, there needs to be a further restructuring of the workflow in the organization. So I would point you, number one, the org chart, that conceptual org chart. Implement that structure. Get a separate section set up, differentiate those licensee complaint cases that require desk investigation from complaints that require a field investigation. Those that require a field investigation go to, and I'm talking again, licensee complaint cases. There's not a huge number of them. It's like 600 or something. Some of them are going to go to the Division of Investigation on the CPEI guidelines. Some go to the investigation section for a non-sworn field investigation, and some get a desk investigation. That needs to be done to reduce the backlog and improve performance, and particularly in the non-sworn what's sitting in the non-sworn investigation section. So in that reorganization, that is the first priority. Secondarily, I would set up the new probation section to augment the staffing and supervision of that unit over the next several years, and by having a supervisor in that unit, reducing the need for use of temporary help. Okay? Number two, having a fully engaged, robust, established, functioning enforcement committee to be actively engaged on a sustained basis in overseeing not just the workload and workflows and performance of the enforcement division, but the full range of enforcement activity and related policy and workforce management issues. Okay?
And yes, and they're here.
So that would include things that are not even mentioned in the report: the disciplinary processes, the use of citations, the fees that are assessed on the citations. There's a broad range of policy issues that really haven't been examined and looked at and are handled differently in this board in comparison to other boards. And it will take a engaged enforcement committee over a period of time to work through, surface those issues, and bring them to the full board for reconsideration. So is it, as an example, the board's practice on a subsequent arrest conviction that's not work-related, not a really serious offense, say an offense like a DUI, okay, with no aggravating circumstances, the board assesses, say, a $500 fine. Some other boards and bureaus don't assess any fines or assess a minimal fine like $250. Why do we assess $500? have you ever thought about it? Should you think about it?
Right.
And maybe it should be more. I don't, there's any number of just kind of issues like that you could be looking at, examining, asking questions about, and affirming the current practice is fine, or determining, hey, maybe we want to change it.
Thank you.
Thank you. At this point, I just want to reorient ourselves because I know other board members do have questions. However, the motion on the floor is to table this item. So if we vote to table this item, I'm not sure the board members that have questions right now would still have them. Mr. de Brownstein, would you like to ask your questions before we vote on the motion?
I will address the motion in my questions. It's been seconded.
Yes.
Okay. Has this report already gone to the legislature?
No.
Okay. When you make your recommendations,
Excuse me, I should qualify. It's available on the website, I believe, correct? Yeah, so anybody can have it, but the Department of Consumer Affairs has not formally submitted the report to the legislature.
okay. Do you have an opportunity to update your recommendations?
At this point, this report is essentially final. It doesn't mean I can't issue an addendum, and of course I have another report I have to put out in 3 months. So, if there's a need to do some updates, do some further review or analysis, then those things, if they're identified, can potentially be incorporated into this next round.
Part of what I see in your recommendations, you're cautious or careful or clear on not getting too far into the weeds on how to implement these recommendations. I heard the chair speak to the idea of taking the recommendations as far as the implementation side and delegating some of that to the committee. And then in your comments, you spoke of the 60 to 70 cases being too much of a caseload, but you don't say, and I think this is a reasonable number of cases for each investigator. The first question out of that is, if you were to update it, or can you today say, yeah, 30 is a reasonable caseload, or whatever?
No, I'm happy to do that.
Yeah.
The answer is they assign, right now they have, about half that number of cases assigned to the investigators, and that's probably a maximum number. Probably an ideal number is something between 20 to 30, as opposed to 30 or more, and that also would depend on the experience and capabilities of the individual staff. It also, again, depends on the mix of cases that they're getting. So to some extent, they're still still working some of these very old cases that add to the complexity and time to work through them, gather the records, and so on. And as they're dealing with what I call fresher cases, then the number of cases they should be able to complete, and actually probably the number they can carry, would be somewhat higher rather than somewhat lower. But for these types of cases, 60 or 70 is not the right number. Okay, it's more like half that or less. And that's kind of the problem right now.
I have the understanding, and I think I kind of got it from you or one of our fellow board members, that the duplicative or supportive reporting, it can be burdensome just in that process. But you spoke of a robust enforcement committee. When you say robust, that's great and it makes me feel good, but can you describe what that is? What is the makeup? Is it a public member? Is it a member of one of our stakeholders from the audience? How many board members? What are you seeing in that?
Well, let's take a look at the history of this board. So as I understand it, for a period of many years, from you all, it's been a long time since the board's had an active, engaged enforcement committee. Maybe 10 years. Or there was a committee, but it was, I think, as one board member expressed to me, a paper exercise. There were members appointed, but the committees never met. In comparison, other boards have had active and engaged committees for a long period of time. It's an institutionalized process. It's an organizational capability that enables oversight of the board's enforcement program, and it builds on itself over time.
And I would agree with you that for many years there was not.
We don't have that history.
But one thing I'd like to clarify is that since Dr. Brown has come on, we have now an enforcement committee. I just wanted to.
I understand that it's now going and it's maybe met a couple of times, but that's not a long-standing track record,
No,
and you don't have all of that accumulated, if you will, intellectual capital, institutional knowledge that gets handed from one member to the next over time.
Going to take time.
Okay?
Right.
So you need something more than just a kind of perfunctory enforcement committee that's going to, I'm not saying that's what you have, but you need something more to kind of catch up with all that hasn't been done for a long period of time. And to build that knowledge of the enforcement program and knowledge of the policies and the updating of the policies that is needed to enable the board to exercise its oversight of the program. And how you choose to, it's your decision as to how to staff and how to scope that enforcement committee's roles and responsibilities and authorities. And I'm going to again base my comments in part on comments made by many of you board members that a two-line statement of scope does not sufficiently delineate what the board's expectations are of the roles and responsibilities of the enforcement committee, so that it's clear not just to the committee about what their roles, responsibilities, and authorities are, but it's clear to all the members of the board and clear to board staff that this is their scope of responsibility. And when you look back at the prior scopes of the enforcement committee, you see in some cases they talk about discipline guidelines. In other cases we talk about workflow. What, isn't it all of that? I mean, then it doesn't talk about discipline. So I would really encourage you to go back and first start off with a more fully developed statement of the roles and responsibilities and authorities and expectations for the committee, and then determine what level of staffing is needed to perform those roles. So I don't think you can answer the number of people until you first better address what you expect that committee to do. That helpful?
That is, thank you.
Okay.
And I'm good moving forward and voting on
We
the
have
motion.
one more question, and I just would like to say that the enforcement committee, I agree with you, Mr. Frank, it's going to take time to catch up and to grow and develop. The members that we have now, Vice President Moreno and Mr. Deerking, I have complete and absolute faith in that they're going to come out with a great statement of responsibilities, and it's going to be very robust. So I think that we are well down the road of creating that robust committee. Again, when you first start out, it takes time to grow. You know, you don't plant a seed and the next day you have an oak tree. So, but I do have full faith in our current committee that is going to be. Vice President Moreno.
Thank you. And our enforcement committee is actually putting forward some of those roles and responsibilities at our November meeting. I wanted to ask, hearing the conversation, reading the recommendations and the comments from our staff, and when I read the recommendations, my thought and my process in reviewing them was that some of them seemed to be duplicative. And I'm wondering now if you can state, after hearing from our board and our board staff, if that at all surprises you, because I don't know your schedule and I don't know if you will be at our November hearing, and if the board does continue this to November, I want to know your thoughts. If that does surprise you, that from my understanding and what I believe board staff has said, that some of the recommendations have already been in place, we're implementing them already, and I'm just wanting to get your thought on that, because I know you said that you did work with staff, so I'm just trying to understand if there is any disconnect there.
Yeah. As I think I expressed to some of you at various points in the project, the report always lags the reality. We did not approach this entire monitor assignment as an audit, where I come in and I gather all my information and I go out and then I give you get back my findings and recommendations. Instead, from the first weeks of the project, I worked collaboratively with management and staff. And as we identified problems, I encouraged them. I said, to begin addressing those problems, and we crafted recommendations that they would already begin to implement. And in a perfect project, the report is lagging the reality on the ground. Ideally, I'm happy every recommendation is already being implemented. There's many that aren't even mentioned in here where we identified problems with data, we corrected the data, it's implemented, it's past history, I don't even mention it in here. There's other ones where, and some of them are examples of the Enforcement Task Force, where recommendations were made, but it's been 2 years, and they're not yet implemented. And by me, and I'm not saying you haven't been working on it or whatever, but by me putting that recommendation into the report, I'm affirming that I agree with that recommendation and facilitating and helping the process, your process, to actually get the recommendation implemented. So that could be said about the legislation to give you authority to delegate defaults, could be said about the fast track program and other areas. So I'm happy if all the recommendations are being implemented. I encourage you to fill out the Gantt chart and show that they're being implemented, and track them and enable you to actually oversee them through to completion by getting them on the game board. So I don't think there's any disconnect between me making a recommendation and you're already implementing it. I say, great.
Thank you for that response. Appreciate that.
Thank you, and I know you've been working very diligently on this report, and you've been working very hard. The one question I have before we vote is, the board members, I'd like you to know that we do get to issue a response to the report. So if we table the report to November 4th, Dr. Brown, is that going to hinder our ability to submit a response timely?
No, we were planning on submitting our response with our sunset report.
Okay, so that wouldn't cause any problems with getting a response. Okay. So at this time, I would like to take a roll call vote on the motion. I'm sorry?
Me, Madam.
I'm sorry. Please, do we have any public comment on the motion at this time? Please, if you would like to come up and state your name and organization.
Yeah, I'm Kobe Pizzati from the California Association of Psychiatric Technicians.
Good afternoon.
I have the unique experience of actually representing the investigations division from a previous employer, and that's California Statewide Law Enforcement Association that represents the sworn and non-sworn investigators. So I do have some concerns with some of the comments made here. When you talk about taking positions or vacant positions from, say, the investigations unit and giving them and creating analyst positions, it is completely doable. However, you would have to notify the bargaining unit, which is bargaining unit 7, that you're going to do that. I'm pretty certain, I'm not going to speak for them, but knowing them, they're probably going to have a problem with that. So the likelihood that you're going to get this done without a fight could be problematic. So I just wanted to put that out for the record. Then the other question that I had was, when the audit was done on the CEs, how many of those audited were state employees? There are some protections in place for state employees to ensure that they are turning in their CEUs with the receipts in order to maintain working. It's part of their responsibilities and their requirements in order to continue working in, say, a prison, developmental center, state hospital, veterans homes. So I'm just curious as how many of those, because we know that my personal members, if they don't turn in their money and their CEs, they don't work. Therefore, there's some pretty good safeguards in place of that. So when I hear the number upwards of 20% are fraudulently claiming that they've turned in their CEs, I'm wondering where that's coming from, because you're talking about a fairly large portion of, at least we're 6,000 members. I'm guessing there's about an additional 4,000 to 5,000 members of SEIU that actually work in prisons and
There's safeguards in place
and
for
other
that.
state agencies. So I'm imagining there's quite a bit. So if you're random sampling the audit, are you touching, I just would like to know where the audit demographics are coming from.
And I'm quite sure we don't have that information today,
Right.
but that's something we can definitely look into and find out.
And I think that's all of my comments, but I just wanted to share that with the board and ask for the consideration of that information.
Thank you, Mr. Pizzotti. That was very helpful. Is there further public comment on this agenda item? Hey, I don't see any at this time. Start with a roll call vote, starting on my far right.
Pardon me, Madam President. May I clarify what the motion was? Because I think it may have had two parts.
John, would you like to?
Yes. The report to be moved to the November meeting due to the timing of the report that was received. And the second part was request that more current data be included to ensure the accuracy of the report. My understanding on looking at some of this information was kind of dated, and the most current information that was done a few months ago was not included with this report. So I'm just want to see about getting the most current data included in this report to find out what the he refers to 15, 16, but there were also other reports and information that was collected. I just want to know if they were included in with this report.
This report, I believe, is final, so I think any extra data would need to come from, would need to be an addendum. So I'm not sure we would have that for November 4th.
I just want to make sure we're on the record that if this information is dated, to make sure we get more current information. Since he has another report due,
3 months.
about 3 months, well, I'll make sure the most accurate information is available.
Of course. Okay, start with a roll call vote, starting on my far right with Ms. Mendoza.
Yes.
Mr. Vertito?
Yes.
I'm a yes. Vice President Moreno?
Yes.
Mr. de Brownstein?
Yes.
Dr. Basti Martinez?
Yes.
Mr. Durking?
Yes.
Thank you. Motion passes. Okay.
We're going to just hold on to these and
Yes.
get an attachment as the update for the November.
I will coordinate with Mr. Frank and Mr. Clifford on next steps.
Thank you for that. That takes us to agenda item number 5, Department of Consumer Affairs Budget Office, review of current VNPT fund. I believe it's Mr. Schick. Is that correct? I'm not sure if I got your name right. I don't know if you want to introduce yourself.
Good morning, members. My name is Taylor Schick, and I'm the budget officer for the department.
Great.
Dr. Brown had asked me to come to this meeting to give you an overview of the board's fund condition, explain to you what we're looking at and what the fund condition's purpose is, what we see it indicating and just give you a better sense of what these numbers actually represent. So in your board meeting materials, you should have 2 fund conditions. There's the chart that looks like this, and I do apologize for the small print, but there's a lot of information on there. And a fund
Yes, please go ahead.
A fund condition is a tool that we use in the budget office, and its primary purpose is to look at the condition of the board's fund at a given point in time, and also to project out what factors might change the condition of that fund over time. So in the sample that you have, you'll notice that the very first number, looking at those columns that go down, are reflective of budget years. And the first number you see there is actually the beginning balance of the board's fund as of fiscal year 2015-16. Now, every number in that column is going to be actual. That's what the board collected in terms of revenues in 2015-16, and then as well as what expenditures came out of that fund in that same fiscal year. When we go down there, then you can see an ending balance. So currently, in the Vocational Nursing and Psychiatric Technicians Fund, there's $12.6 million in the fund, which represents a fund balance of 11.2 months in reserve, meaning that if all revenue were to cease, the board would be able to continue operations for close to 1 full year without going insolvent or without running out of funding. What this does reflect, though, is it shows actual expenditures versus total authorized expenditures. And we do know that the board actually did revert a very sizable amount of their appropriation last year, and we do not believe that trend is going to continue. The next 3 columns, though, are the next 3 fiscal years that we're looking at. The first one that says Budget Act, right above it, is the current year, 2016-17. That's the fiscal year that we're currently in. All these figures are projections. These are the revenues that we're projecting to come in for the year, and it is also reflective of your full authorized appropriation for 16-17. The one thing to note about this year is what we can already see as a trend here is that the board's total authorized expenditures is outpacing our projected revenue that's coming in at a rate of close to $2 million. So while you have $12 million in the fund right now, this fund condition is projecting that that amount in reserves is actually going to drop down to about $7.9 million by 18-19. Keep in mind, any fund condition that's prepared by the budget office is sort of point in time, and the information is only as good as the information we have at that time. Anything that's in 16-17, 17-18, 18-19, those are all projected figures. There's a second fund condition that I prepared as well to give you a more realistic look. The first one's more indicative of what's currently in the governor's budget. The next one is going to display one of the changes I know that's going to occur that's going to impact the board's fund in the next coming years. To give you a broad sense of things, currently in my budget shop, we're building the authorized budgets for all the boards and bureaus within the department for fiscal year 17-18. We're in the middle of 16-17, but we're already developing what that year is going to be for the next budget cycle, for the next budget act. So we're always working about 18 months to 6 months in advance of the next budget. One of the things that you may even recall from the report that was just provided is that the hours that have been utilized by the Division of Investigation have been going up in recent years, where they all but sort of ceased in like 12-13, 13-14, but they started to increase in 14-15 and 15-16. When I build the budget for the department or the Division of Investigation, I'm using the last full year of information that's at my disposal for the year I'm building. So when I'm building the budget for fiscal year 2017-18, the last full year of data that I have is going to be fiscal year 2015-16. But we're in a situation where, based on how that pro rata for the Division of Investigation sort of rolls, there were a couple years where the board's budget for the Division of Investigation was basically $0. You weren't paying for anything because the workload provided by DFI wasn't there. But now that it started to pick up again, we're going to see that pendulum swing to the other side. And so this fund condition is going to show a fairly sizable increase to your overall budget authority to reflect basically what you owe DFI for those services that were provided in 15-16. So you do see a line there under the expenditures near the bottom of the sheet You'll see program expenditures. That's the same as it was on the previous fund condition, but you'll see a second line that says estimated increase in DFI enforcement costs. And you can see a cost there of about 2.8 million in 17-18 and about 2.5 million in 18-19. And if I took this out long enough, we'll actually see that amount drop down again, probably to about 700,000, but then swing back up to about 1 million to 1.5 based on projections and various meetings that we've had between the board and the Division of Investigation of where we think the corrected level of cases that are going to be provided to DFI are going to end up. Obviously, we're dealing with a big fluctuation because the number of cases that were sent to the division basically went to zero. Now we've sent a huge backlog there. We imagine that backlog is going to be worked through in these couple years, and then it'll even out to a more normal amount of cases going to the division. But that's a real cost. So I wanted to make sure that was included in this fund condition so you could see what that impact is. There's going to be a couple other factors that will ultimately will impact the board's fund condition that we're working on in the current budget building process. One is for an employee compensation increase. A lot of the bargaining units are getting pay raises. We don't have the final figures for that yet, but that will be something that will be included in the 17-18 budget. There's also always changes to retirement rate increases. So there's other factors that will change these numbers. So that's why I mentioned that this is a point in time reflection of where we think the fund is going. So based on that second fund condition with that estimated increase in Division of Investigation figures, instead of the fund dropping down to about 7.9 million at the end of 18-19, I'm estimating it's going to be closer to 2.5 million by the end of 18-19. So that's just to give you a sense of what's going on with the fund condition, and I know there's going to be discussions regarding a fee audit later this meeting.
Exactly.
And just to let you know, we like to get out in front. While you might have $12 million in the fund right now, 12 months worth in reserve, it takes time. This is state government. Things need to go through the administration. They need to go through the legislative process. To implement a fee increase of any type, there's a lot of oversight and people reviewing that. And it can take upwards to 3 years to implement any change like that. So I just want that to be in your mind, because the way state bureaucracy moves, it's a different type of animal. You can't just turn around and implement a change. There's a lot of sets of eyes that are going to be reviewing that before it can go forward. But that's my primary purpose today, was to go through these fund conditions, make sure you understand them, you understand the data that's coming out of these. And with that being said, I'd open it up for any questions you might have on the fund conditions.
Thank you very much. I do have one question. Something that's consistently mysterious to me is when we get these reports, there's talk of, well, we have BCPs out there, budget change proposals out there. It's not included in here. It is included in here, and the numbers vary greatly. So what's that status? What's the does this include the budget change proposals? I mean,
this one right now doesn't include the budget change proposals. It only shows an estimated increase in cost of DFI. There's a lot of things that when we're working on the budget, typically those are working documents. We try to keep them as confidential as possible in the case that something doesn't go forward.
Okay.
To the extent possible, if you want sort of maybe a proposed increase of what the board's thinking of doing, we can include that, but we just need to make sure that we're clearly delineating it, as these are proposed expenditures.
They're not.
These might not get approved, this might not go forward, and when we're talking about budget change proposals, those need to get through our Department of Finance before they can even be included in the governor's budget, and they have a fiduciary responsibility, as we do as the department, to look and see, would these types of increases in your appropriation detrimentally impact the fund. So that's one of the things they're always looking at, and when that's the case, typically the response that's going to come out of our office or the Department of Finance is, well, you need to make a correction. You need to prove to us that if we did authorize your ability to expend additional resources, you would be able to support it with your existing fund, because they don't want to put you in a situation, they don't want to approve additional resources, and then 1 year later, you don't have any money in the fund, and then you need to go through layoffs and other types of actions that we really don't want any program to go through in order to maintain a fund balance.
Any other questions from board members at this time? Mr. Vertito.
Thank you, Madam Chair. Sir, just to be clarify, on pro rata, since we're going to DOI, we give them the cases, and then pro rata means they just send us a bill and we have to pay for it. Is that correct? There's no hourly cost to do the investigation. There's no estimate. We can't budget because we don't know what we're going to be charged.
So part of it is that's what the pro rata process is, and we'll actually be having a meeting next week to talk about the department's distributed costs. But that's one of the things that we implemented to allow for programs that utilize DFI. They don't have to worry necessarily about that billing in that existing years, because in certain cases you might have cases you need to send to the Division of Investigation, but you don't have appropriation that year to pay for it. Because of that, we've implemented what's known as that 2-year roll forward methodology. So we're always building programs budgets. We're augmenting your appropriation to pay for DFI services that were provided 2 years in arrears. So it is not a true hourly billing rate. I'm building out DFI's costs to be recovered in full by all the programs that utilize their services. The data that I'm using to distribute that cost out is the data that I'm receiving from the last full fiscal year of hours provided. I can extrapolate an hour per service out of there, but it's not a true billing rate, if that makes sense.
It does, which is kind of scary because, you know, when I do a budget at home, I know how much it's going to cost, and I could plan accordingly. I need to put away $100, $1,000 to pay car, rent, power, water. But with the DOI pro rata, I really don't know what I'm going to be paying. They send me a bill, and it's like I budgeted for $100,000, and it's $150,000 or $200,000. So it's kind of hard to build a budget on something where you don't know what the cost is going to be, isn't it?
I do appreciate that. Yes, I mean, we're building this budget based on hours received, and if you weren't estimating for those hours to be incurred in that year, you may be going forward thinking everything's fine, and all of a sudden, as this fund condition shows, we're hitting you with close to $2.8 million in additional costs. So I do appreciate that. Where I think that comes in, and where I think maybe that was missed in the past, was the level of communication between the division and the board and the budget office altogether to really find out what's going on with the amount of hours that they're incurring, because it had all but dropped off, and we didn't know if that trend was going to continue or not continue. So what we've been doing more recently is having those conversations between board staff and the division to really get a good sense of what those out year costs are going to be, and to try to stabilize it so we don't have swings like this. Because I do agree, when you have sort of that unknown of how many cases you're going to have at the Division of Investigation and how those dollar costs are going to swing, it does make it hard to do your responsibility of adjusting fees or making sure you have enough in reserves to support the program.
Okay, because one of the things, I've been on the board long enough to know, one of the reasons why we even set up our own section of investigation is, as reported previously, the investigators were getting somewhere on the average of about 100 cases each. And so that was one of the contributing factors to case aging. And the previous director thought, or previous CEO thought, that by having our own investigative system in-house, we'd be able to address that. But that was also at the same time where the budget for the entire state fell apart, where the housing market tanked, and we got many false starts. But again, the thing I'm concerned about is, if I compare this to my household budget to what we're doing here, it's almost like you need a crystal ball to try to figure out what type of bills are coming in and how much is coming. Yet we have a fixed income, and it's kind of scary if you're going to get a bill and you don't know what's going to be. And you just said $2.5 million. I'm going, oh, okay, we budgeted $1 million and it just went double and a half. So I appreciate your crystal ball. I'm just hoping it's going to affect us. And when I see red ink on our on the budgets coming up, it's something that we have to address, and we are trying to be responsible and address it. But I don't, as much as it scares me, I kind of like to know what's coming, and then before it gets here, so I have a rough estimate. Essentially, I don't envy you, But I do appreciate the effort in trying to get us up to date on this, but sometimes pro rata scares me, because we don't know what's coming.
And I agree with you, Mr. Schick. I know there's been increased communication with our enforcement chief, Gina Bayless, our executive officer, Dr. Brown, your office, and DOI. So I'm glad that that's happening, and I think it's going to lead us down the right road. Any other board member questions? Dr. Basti Martinez?
Thank you. And thank you very much. That was very informative. I was struck by the rapid potential decrease in the reserves. That's a huge potential drop. Is there any regulation or edict in the department that says various boards should maintain, or they recommend boards maintain a certain level of reserve?
So
And
there
what
is a
is it?
statute within the Business and Profession Code that establishes a maximum reserve that most programs should have before they need to address fees by lowering them. By and large, most programs don't have a minimum, but in working with the Department of Finance, they tend to strive to have no program have less than about 3 months in reserves within their budget. But obviously, when you have, strong fluctuations like this,
Right.
we can get down to that level, and sometimes with a program your size, 3 months in reserve might not be enough to put in there to account for sort of those fluctuations. One of the other things I should mention is when we're looking at those budget years, this does assume that you're spending your full appropriation as authorized. Typically, programs do revert anywhere from about 3 to 5% of their appropriation every year, just due to either salary savings because of vacancies or not utilizing their full OE&E. This last year, we saw the board revert a sizable amount of money, but we don't anticipate that's going to continue. The trend actually with this board and typical reversions has been less than about 400,000. So that's one of the things we do look at, but this is sort of right now looking at worst case scenario of the information that we have on hand and what we know is going to hit the program.
This might be pushing it, but from your professional opinion, what would you say we should be looking at in terms of a reserve?
For this,
Given what you know about our circumstance.
For this one, I would want to see your reserve stay at a fairly steady rate, probably around 6 months in reserve.
And that figure?
Probably about 6 months, between 6 months and 12 months, which would be a figure right around, I would say, about $8 million to $12 million. And of course, that figure will change depending on the size of the appropriation. So if the appropriation does increase for various changes like this, that amount in reserve that you should maintain is going to change.
Thank you.
Thank you. Is there any other board member comments or questions? Okay, there's no motion necessary on this item. At this time, I'd like to take public comment on this item. Any public comment? Seeing none. As I said, there's no motion required on the report. Thank you, Mr. Schick.
There were 2 other documents in this report, not necessarily that I own them, but there are 2 spreadsheets regarding the Breeze project.
Okay. Did you want
so
to
I
go
didn't know
over
if
them?
you wanted to address any questions you might have on those. I can walk you through what that first spreadsheet looks like.
Yes, I'd like to go through Breeze, please.
Sure. So I believe in your meeting materials right after the fund conditions, you should have a landscape chart that looks like this. This is a report of the costs of the Breeze project. You'll notice I have it going all the way back from fiscal year 2009-10, and I'm showing it out through fiscal year 18-19. And everything through fiscal year 2015-16 is reflective of your actual expenditures towards the project. And 16-17 is going to be budgeted, and 17-18 and 18-19 right now are projected. So those numbers could change. That's part of like a BCP process, so we don't know what those final figures might be, but those are our best projection of what those costs are at this point in time.
Now, we are the second round of release.
Release 2,
correct?
yes.
And there's between the first and second round of release, there were fixes and changes made. Is there a third round of release?
So the release 3 was essentially stalled when we did what's known as a special project report 3.1 for the project based on various risks that were identified by the Bureau of State Audits. We actually closed the project out and closed it at release 2.
There will be no release 3?
So there is still going to be an ultimate IT solution for all those programs that were in release 3, but we have to go back through the process to determine whether or not it's going to be Breeze or another IT system.
And my concern is, I've said before, even though it's called Breeze, it hit us a little bit like a hurricane. So if there's another release and there's fixes, will we then absorb some of the costs for those fixes? But like you're saying, you don't know if it's going to be
Or a
Breeze.
third, I can't speak to that right now. What I have right now is what we project the board is going to be paying for the continued maintenance of Breeze. I can say that what's reflected in this chart, especially in 16, 17, 17, 18, 18, 19, these are the peak years. This is the years of the payback of all the work that Accenture had provided, and it will start going down fairly dramatically until it reaches fairly a level point. But I do want to caution that leveling off is probably not going to occur until about 2021, 22. We do have a distributed cost meeting that we're going to be hosting here at the department next week, and we're going to hopefully have charts that are actually going to show that full range for every program, so you can sort of see that bell curve of the project costs going into more of an elongated, here's what the maintenance cost is once all those contracts
plateauing,
yes,
sort of, in a way.
Exactly.
Any questions from board members about the Breeze report? Any public comment about Breeze, the item Breeze report itself? I don't see any. Again, there is no motion required on this report. Does that conclude your report?
This would conclude my report.
Thank you very much, Mr. Schick.
Thank you for having me.
Great. Our next agenda item is number 6, discussion and possible action on 2016 Draft Board Member Administrative Procedure Manual. And I believe everyone received that material in their packet. Dr. Brown, would you like to lead our discussion on this?
Thank you, Madam President. So if you remember, you received this this manual before in draft form. What I wanted, the changes that are relevant was after collaborating with our legal counsel to make sure we had updated regulations, there was fleshed out language, and so that was the updates from the last draft. I want to backtrack and talk a little bit about how this manual came to be. Every board does have a administrative procedural manual for how they're going to operate internally. What we did is we basically took the best of the best. There were boards that had award-winning, I'm not sure where they got them from, but award-winning administrative procedure manuals. We literally took that verbiage as is. So this is not new thought. This is literally a cut and paste and meld those together. So I want to just, and then with the help again with legal, we edited to make sure the regulations were up to date. So this is really just a high level. In thinking about how you would use this manual, I want us to picture an hourglass shape. You're going to have first the BMONT training, which is just going to give you the overview of how to do board member training and what everyone does. And then the next step would be our own board-specific manual, which is talking about how we're going to operate internally. The next thing that's going to happen that's forthcoming is that we're going to start having internally our own kind of updates and trainings so that board members and different committee members have a better comfort level in what's my role on this committee? What's my role in terms of being evaluating and assessing policies related to voc nursing and psych techs. So I want us to know that that's the next thing that's coming. But if you think about that hourglass, we're basically narrowing in and being more focused on on our committee, and that's so that we can actually do the work of the consumer protection more efficiently and more correctly. So the other thing I want to call out, because it came up in an email, is I want to just go to one particular page and just have a little conversation around it. And that page would actually be, should have had this. Alrighty, this is on page 7. And so under page 7, it says rules of contacting staff. And it's saying that aside from that, no one should deviate other than those areas and should go through the EO. And so I want to talk a little bit about that. This is in no way telling you that you should not be contacting, say, the chief of enforcement or our acting assistant executive officer. What we're trying to do is, as the board's employee, I want to make sure that you guys are kind of getting consistent messaging and consistent information. And so when you reach out to, say, the chief of enforcement, the ask is not that you limit that or go through me. We're not trying to have redundancies, but more that you include should there be any other context that you may need. The other thing that we've actually seen that has come up is at times a board member may reach out to a staff that is not in the senior level position, and some information may be shared that really skirts the line of being slightly inappropriate, may actually impact, closed session, or may be something that if two of you then ask, it feels like an Open Meeting Act violation. And so we just want to have, appreciating that we shouldn't expect staff to know that, but appreciating that you guys do want me to know that, we're just asking for that inclusion. So it is no way barring you from actually engaging with staff. It's really just redundancies. Should there be something that I can actually check in on and say, hey, this is what they actually mean, or hey, this is something we've actually updated on. So I just hope that this language, again, was boilerplate, but we wanted to make sure that you understood the spirit of the language.
And I agree with you, what you said, that it's very common language in this situation. Also, one thing that's just common knowledge and common sense, I think, for all our board members is I've contacted Cheryl, I've contacted Gina, and I just always CC Dr. Brown, so we stay within communication. I think that's just a regular procedure. I see legal. Do you have a comment?
Yeah, may I? Our legal office likes to draw attention to, kind of as an overview type of comment. On page 1, the last paragraph talks about, kind of as Dr. Brown was directing the use of the manual, but this paragraph talks about it specifically. It says this procedure manual is updated as necessary and provided as a ready reference of important laws, regulations, department policies, and board policies. It's designed to help guide the actions of the board members and inform the public. So primarily to point out that this works within existing law. And a couple other real minor comments. One is, it might be helpful to have a footnote that just notes the date if and when when it's adopted. And Dr. Brown, you brought up page 7 and specifically that rules for contacting staff. I think that was a helpful comment, and maybe language-wise, what could help demonstrate that is to say something to the effect of, it's recommended the board members contact the following designated staff. I mean, maybe that kind of change of language could help explain what you were saying. And the final thing I would point out is on page 12, in relation to the committees that are proposed there, the Education Committee already has an additional task delegated to it that would be helpful to explain in its description. So those were my only suggestions or comments.
Do board members have questions about the Administrative Procedures Manual?
I have a question.
Vice President Moreno?
On page 2, just for clarification, under board member participation, it states any 2 unexcused absences in a calendar year will result in an evaluation. I'm just wondering, does that refer to our regular quarterly board meetings, or does that refer to any meetings? Like, I know this was a special meeting that in the beginning of the year we did not anticipate, and I'm present, but had I not been able to make it, I would hate to think that this would count as an unexcused absence if I just wasn't going to be able to make it here. So just some clarification on
Yes.
on what those those
My
two unexcused
understanding-
absences would be.
My understanding is, and I'm looking it up right now, the way I interpret it is if you even call and say you're unable to make it, then that's an excused absence. Unexcused absence is a complete no-show.
Okay.
Is that also, yes, Dr. Brown? So that's just, you say you're going to be there and just don't show at all. But yes, we know that board members have obligations, professional obligations in their life, and sometimes cannot make meetings. It's just requested that you would notify either Dr. Brown or myself if you're not able to make a meeting.
Thank you so much.
I don't see any other questions. I would like to make a motion to accept the Administrative Procedures Manual, except add the date line and also add the new responsibilities of the Education Committee.
I would second that, but I also ask to amend the recommendation about contacting members of the staff for that clarification also, as recommended.
Sure. So let me restate that then. I would move to accept the Board Member Administrative Procedure Manual with the addition of adding a date line, adding the language of recommended lines of communication, and adding the new recent duties of the Education Committee.
I'll second that.
At this point, is there any public comment on the Board Member Administrative Manual? I don't see any. Any further board discussion? Mr. De Brownstein?
This may be for legal, but every time this manual is revised, is it going to have to come back before the full board? Or can it just remain a living document under the purview of the executive committee?
This encapsulates your board policies, so these reflect actions of the full board. So any changes would come before the full board. If there, for example, was a change to existing law, like let's say there was a change to Bagley-Keene or something, that's not reflecting a board policy, but if the change was then reflected in your manual, you should bring it in front of the board and then adopt the new board policy manual that reflects existing law. So it's designed to allow you to address those on an ongoing basis. So, for example, your committee page, you've got new committees. If those roles change with time, you would take a look at your entire policy manual and make sure it, as a board with a full board action, reflects the will of the board for those things. So.
Dr. Basti Martinez, did you have a question?
Was reflecting if the question were necessary. If I'm hearing correctly, we're talking about substantive changes. Grammatical errors, spelling, etc., would not be included.
You could make that intention clear now if you'd like. You could say for any non-substantive, well, I think unlike regulations, you probably want to maintain that this is the document you've adopted. And then if any changes are made, it gets brought before you.
Even grammatical that's...
Again, the board can express its intent either way, but you'd want to clarify what you mean by grammatical or non-substantive versus what you would maybe consider a substantive change to some of the policies and suggestions.
Thank you. I withdraw my question.
Thank you, Dr. Basti Martinez. I don't see any other board member questions at this time. There's a motion on the floor. It has been seconded. Take a roll call vote, starting with...
May we call for public comment on the motion as well?
We did.
Oh, did I miss that? Excuse me. Sorry.
Take a roll call vote, starting on my far left. Mr. Deerking?
Yes.
Dr. Basti Martinez?
Yes.
Mr. Mr. De Brownstein? Mr. De Brownstein?
I vote yes.
Vice President Moreno?
Yes.
I'm a yes. Mr. Vertito?
Yes.
Ms. Endozo?
Yes.
Thank you. Motion carries. And at this time, our next agenda item would be the fee audit. Mr. Eds will not be here till 1 o'clock, and it's quickly approaching 12 o'clock, which is lunchtime. So at this time, we're going to break for lunch, and come back at 12:45. Thank you. For coming back in a timely manner. We're going to get started with the next agenda item, but actually before that, I did want to make an announcement that I failed to make this morning. Dr. Brown did allude to it, but I would like board members and the public to know, and anyone who's watching, that our own Cheryl Anderson has agreed to take on the current acting assistant executive officer position at the board. So we're glad to have such a competent and qualified person in that position, and we thank you for taking on the extra responsibilities as the acting assistant executive officer. So we just wanted to say thank you to you. Okay, this leads us to item number 7. Discussion and potential action on fee audit report. We have Mr. Eds here, and Mr. Eds, I know you were at our last meeting. I thank you for coming back and joining us. We do have your materials that you presented, that you've given to us, so we've read your report. Feel free to start your presentation at any time.
Good afternoon.
Good afternoon.
This on? Sounds like it. It's nice to be back with you again. I think we're going to have the PowerPoint up and running momentarily. While that is coming up, let me just bring you up to date on what we have done since we were together in August, I think it was. I went through and with budget assistance went through and we updated all of the data to fiscal 2016-17 numbers for both all of the services and supplies, as well as labor costs. Taylor and I were going over those numbers. I think it was 4 o'clock afternoon, last Monday afternoon, which was a little tighter than my stomach likes to enjoy, but we got it done. And so he's reviewed the numbers. We've agreed on the numbers all across the board. So with that, how close are we? Okay. Why don't I just go ahead and it would be page 2. We'll just go ahead and start the summary. Page 2, the project included, or this presentation has a couple of parts to it. One is the scope and methodology. And if you can sort of take the idea that there's 2 main phases to this report, looking at the scope and methodology, and then the second phase looking at the actual results. And those are broken down into individual fee requirements based on current budget. And then we have another few slides based on some additional resources that are being requested, and then just some general high-level recommendations. So if you want to go to page 3, that's the introduction to the scope. Page 4 is the project scope, which was to include calculate the full cost of processing licenses for individual licensees and educational institutions. 2, calculate the direct cost of processing licenses and allocate the support cost, such as investigations, enforcement, and other support functions that may apply. And actually, this is a fairly important part of the analysis, and I'll get into more of that later. And then finally, to develop long-term fee projections going out as far as 10 years so that you can set the caps if you care to go that far forward. Okay, page 5. We'll just move right along. I assume you do all have this in front of you. Okay, page 5. This is very much a high-level summary of the process that we go through in these projects. The first one is to establish the full cost of the services, which sounds pretty simple, and it wasn't a big deal in this project, but sometimes, depending upon the structures of the budget and just the way the budget offices work, It can be a bit of a challenge, but the first order of business generally is what kind of dollars are we looking for? And even more so, how do those dollars get allocated out to the various operating units of the organization? The second one, core business processes. This is really the heart and soul of the analysis, where we're looking to identify the core business processes. We're looking to determine the relationship between business processes and specific fees. For this project, business processes include things like administrative support. It includes things like enforcement and various pieces, major pieces of the enforcement activity. It includes things like telephone support, answering the phones, and then the individual activities of actually processing licenses and applications. And then allocate support costs for enforcement, investigations, cash sharing, et cetera. And again, this is a fairly important part of the analysis because the direct cost of actually processing any individual license is that relatively small, which I will show you in just a moment. It really becomes calculating the full cost really becomes an exercise of allocation of cost as opposed to looking at direct cost. Now, in these projects, frequently people will say, well, how do you know if you're getting good data? And so this next slide on page 6 summarizes one of the ways that we determine whether or not the data that we're getting is good. One of those things is that we look at the total resources that we have to work with. So in this case, we have a little over $15 million of budgeted resources to work with. And when I create a model, I actually have to end up with $15 million of revenue. I set it up so it's a zero-sum game. I can't have more revenue. I can't have less revenue than I have expenses. And if I do, I've got my little Excel spreadsheet here, and it starts flashing me red cells, start flashing me red lights. And I could show you if you want to see them for artistic purposes. But so everything, total resources going in, total resources or revenue coming out have to equate. The second one is hours. So if, in this case, we use 1,776 total hours per FTE, that equates out to a total number of hours. And again, hours coming into the model have to equal hours coming out of the model. So we've got 120,590 hours. I have to account for 120,590 hours in the model. So those are the two primary things that we're looking at. In this case, we're also looking at a projection of revenue. So I project out revenue, which the math is pretty simple. It's how many times does the staff process a renewal permit of some sort, and multiply that times the current price, and the total of that I need to account for within a pretty tight frame. I'm usually comfortable with like 5 to 10% variance in these projects. Actually, I like to get it down to 1 or 2%. And then we also looked at projected revenue from the analysis and compared that to actual revenue or projected revenue from, in this case, the sunset review. And again, if I'm in the ballpark, preferably inside the inner circle, then I'm happy. And you can see I'm $1,578 difference. So when I'm looking at those things, I'm saying, okay, we've got good data. The results are balancing out. The numbers are coming in where they should be. Now, and by the way, if you have a question, don't wait till the end. Just raise your hand, stop me. I'm more than happy to respond. There are a couple of assumptions built into this model. One of which is that the organization remains fully staffed throughout the year. In other words, if there's 70 FTE that's been assigned to the organization, that 70 FTE are actually filled doing the work throughout the year. The other assumption is that the organization spends 100% of its budget. Now, we all know That's probably not totally realistic, but it's a way of assigning cost, probably the most conservative way, if in fact the organization is a little more fiscally conservative, or if staffing, people don't just quit on one day and they get replaced the next day. If there's lags in that hiring process, in the transition process, then you will actually end up with fund balances. And my gut tells me that that's why you have been increasing in your fund balances, because the organization hasn't been spending all of its money. Question about that? Okay. The results, which actually start on page 8. Again, a couple more, actually one more assumption. Besides that the budget expenditures will be spent, there's another very basic assumption in the analysis, and that's that the number of licensees will stay constant. In other words, the number of vocational nurses applying for a license or a renewal license will stay constant over time. And if those renewals and those licenses, if they're highly volatile, then we would certainly want to take that into account. In this case, they're pretty stable. Actually, they're quite stable, as slide 9 will show you. The revenues coming in from processing licenses has been really quite stable, and you can see that across the top.
Mr. Eds, I'm
Yes.
sorry, I do actually have a question. You were saying that your projections are based on the number of applicants for licenses remaining stable, but in fact, it's probably, my opinion, going to go up. New programs are opening up. But that, in fact, would not hurt us, but possibly benefit us, right?
Sure.
Okay.
Sure. It just means you have more revenue coming in.
Okay, thank you.
Most of the time, that's a good thing. Yeah. And it means, in your case, that you would probably rebuild your fund balances a little faster. Okay. And it would mean that you wouldn't have to increase your fees in 2, 3, 4, 5 years from now. Good. Any other question? Thank you for that. Okay. So again, page 9 shows quite stable revenues from licensees over the last 4, 5, 6 years. And again, if those numbers were highly volatile, we would have to take that into consideration and do some averaging. But in this case, I just took 1 year of activity, or the number of licenses that are being processed. I just took 1 year and assumed that that was representative of the near past and potentially the near future, withstanding some additional programs coming in. Any question about that? Okay, page 10. Projections of net revenues through the end of this fiscal year. Again, this is my projection. It is not necessarily the budget office's projection, but the numbers have to be quite close to what the budget office says. If their numbers were radically different than mine, I'd want to know why. But as you could see, my projection of current revenues is right at $12 million. The math is pretty simple. It's how many times does a vocational nurse or vocational nurses apply for a license, multiply that times the current fee for the license, and you add it all up, and it comes up to $12 million. Now, let me note that this does not include anything from citations and fines. I did not include those revenues, A, because they're minuscule, they're quite small, and B, you don't have any control over them. So I'm trying to focus on what you actually have control of. Current expenses projection is $15 million, almost $2 million, which leaves a $3.2 million difference between your projected revenues and expenses. Questions? Okay. Now I want to show you on page 11 an example of one of the way that the numbers actually calculate out. And this is for a curriculum revision major, which is actually a new fee that we established. And you'll see there that the processing requirement that we estimated to be 9.53 hours. The direct hourly rate is $83.90, and that rate includes salaries and benefits and a prorated amount for services and supplies. Does not include any administrative overhead either from the board or from the department or the state. That gives us a direct cost of $800, $799.57 to be exact. We then allocate various costs. One is the state pro rata, that's $409. Department management and administration, that's $677. And then support services from the counter, mailroom, information systems, cashiering, et cetera, at $1,052 for a total cost of $2,939. Question on this? You will also note that in this particular one, there is no allocated cost for enforcement. And that is because the educational nursing group, which does this work, they do their own enforcement. They don't turn that over to the regular enforcement function. Okay. Page 12. This is to provide you with a sense of the total cost of enforcement, which I calculated to be $10.2 million, or a very high percentage of your total cost. Now, this is the actual budgeted cost for the various enforcement functions, and it also includes then a prorated amount for the statewide overhead, department overhead, board administrative overhead, et cetera. So it's really a statement of full cost, and it shows again that there's over $10 million consumed in total for enforcement activities. If you'd like to turn to page 13, this will actually show you the breakdown. Very good. So that top bar on the left-hand side in my document, it's green. That is the internal cost for probation. The red bar in the middle there is the cost of investigations into complaints, and the blue bar is evaluations and resolutions. Those are the three primary functions, or the primary processes of the enforcement program. And then you will see next to that, it's purple, $1.5 million of additional DCA enforcement cost. Now, a bit of a background to that. And Dr. Brown, if I don't say this exactly right, correct me if I'm wrong. But over the next 10 years, there's a projection that the DCA enforcement staff will have to supplement your own enforcement staff. And so in conversations with Taylor, it was determined that we would assume $1.5 million equal amounts over the next 10 years, even though there's going to be years where it's higher, there's going to be years where it's lower. But on balance, we arrived at a number of $1.5 million. Now, Dr. Brown, did I say that right?
Yes, and so what this is, again, when Taylor did a great job of setting up the foundation. So this is related to, remember that 2-year kind of, when you're paying it forward because of DFI costs. Well, we had, starting in 2014, 2015, a huge amount of cases that are over in DFI, and so now those are being worked, and so we are projecting that with that, we are going to have basically an uptick until probably 18, 19, of them resolving those cases, right? And then it will start to plateau down, and so we have to build in for that. But this is an irregular spike. Had we not ceased all of our operations, we would not actually be accounting for that because we'd have an actual projection to model off of. Does that help?
Thank you. And then the third lighter blue bar to the right of that says $2.4 million for the AG cost, hearings and witnesses, and that would be costs that are being assigned to you from the Attorney General's office or the Office of Administrative Hearings. And then when you add all that up, comes to $10.2 million. Question about that? Okay. And so with enforcement cost being high relative to the total cost, I thought it'd be appropriate that you understand how we allocated or how we assigned that cost to individual licensees. Again, these costs are not being assigned to the institutions because the educational staff are fulfilling that function. And basically, there's two ways of doing this. One, I could take all of that cost and layer in on top like an overhead function, just simple prorated out based on the direct cost of processing an individual license and application. In this case, we decided to set up essentially a flat fee, if you will, that would go inside an individual fee, so that every individual license is going to carry a cost of $134.61. And that's to recover the cost of enforcement. Now, is there any question about that, about why we did it that way, or how does that work? Okay. So page 15, review a fee structure. Again, this is just as an example. This is for an initial application for examination and license for California Vocational Nursing Program graduate. On the columns to the far left, there we go. Want to go one more over. There you go. So why that is coming up as a value, I do not know. But on mine, it's there's $18 of essentially direct cost. There's $53 of indirect support cost and $135 for enforcement cost, for a total of, I have no idea why that came up that way, $205 for the cost of this particular license, as opposed to $150 that it actually cost, or that you're actually charging for right now. Okay. One of the major outputs of these kinds of projects is to get the fee schedule itself aligned with current processes and procedures, as well as the people that are served. And so in this case, we ended up working with staff. We designed 9 new additional educational fees, and these are primarily for educational providers. And then if you would like to flip to the next page, page 17, this shows you essentially the percentage or the amount of revenue that's coming currently from the providers. And as you can see, it's a very small amount, which says that the individual licensees are paying for the cost of the institutions and for those permits that are being supplied to the institutions. If you'd like to turn to the next page, slide 18, it shows that based on the results that we calculated, and by adding those additional educational provider fees, your revenues essentially would go up to $2.3 million from the educational providers. So that's shifting a significant amount of revenue away from individual licensees to educational providers. Is there any question about that? Yes, sir.
So you're telling me the revenue or the educational programs that you listed in this?
Right. Perfect. Yep. Couldn't say it better myself. Okay.
And then why did the part in the blue change? Where we're talking about the individual licensees proposed, it went up in the second model?
Okay. Well, the individual licensees in the blue went from 11.9. Now, under the proposed fee schedule, it's going up to 12.8.
Is that to make the numbers at the beginning
Yeah.
line up? Okay, so
Right.
that
Yeah.
Gotcha.
Yeah, it's completely reshuffling the numbers, going from where you're at currently to where you would be at if you adopted the fee schedule as we have laid it out. Thank you. Any other questions? Okay, slide number 19. This breaks those same numbers down to a little bit more detail. On the left-hand side, you see the current revenues, 10.3 million in the blue bar, 2.6 million in the red bar. That is from psychiatric technicians. And then the green bar is relatively flat at $9,440. And under the new fee schedule that we have developed, the blue bar goes from 10.3 to 11.8. The red bar, or the psychiatric tech revenues, goes from 2.6 to a little over $1 million, and then the revenues from individual licensees goes up to 2.3. Any question about that? Let me just point out one thing that may come up as a question. If you look at this carefully, you see that the revenues from psychiatric technicians actually goes down. That's not necessarily because costs are being shifted from the psychiatric techs to the educational institutions. In a major way, it actually means that one of the primary sources of revenue is the annual renewals. And I believe you're currently charging like $300 for that, and the cost is like $150. So that's the primary reason why that number goes down.
And since you brought it up, that's one thing that we've talked about before in this committee, is that historically the psych tech renewal fee at $300, in my opinion, was unacceptably high. A veterinarian who renews their license is only $290. A doctorate level psychologist, it's less than. We were paying more than psychologists and veterinarians, and I know that we have working class people who are working as psych techs, and it was a great burden on them actually to renew their fee. So I know I've been saying it for years that fee has been too high. So yes, I noticed in there that you have actually changed that.
Yeah. Well, I did not change it because out of any sense of equity with other professions.
That's my opinion. That's my personal opinion.
I will leave that one to you.
Okay.
But as we looked at it, we realized it doesn't cost any more to process a renewal for a vocational nurse as it does a psychiatric tech. And so we didn't target to make those costs the same, but we had the same time estimates, the same input, and so they come out to be the same.
The work that goes into it is the same.
Work goes into it's the same.
Okay.
Okay. Any question about that? Okay, so the next slide is 20, titled Building a Sustainable Future. And I actually ended up building two models, one based on essentially the current budget, and then another model based on some additional resources that have been requested. And I'm going to leave Dr. Brown to explain the detail of that.
Sure. So if you guys remember, one of the things that we're actually striving for is, while it is great that after almost a decade that we have 5 NECs, if you look at the almost 170 programs we have, that is still not enough to actually cover the entire state. The other thing is that since 2010 to now, our program increase has been about 140% in total. So if this continues in terms of educational programs continue primarily proprietary, we need a greater bench or a greater education division. So that was one of the primary proposals last year that we still would like to consider and build, and that would actually basically double our team. So we would add 5 more NECs, as well as we would add related administrative staff, and that's so that we can actually effectively do on-site visits for education divisions across the state. Currently, there's approximately one NEC per 33 educational institutions. And so if you think about that, just that evaluation that comes up, whether it's every year, every 4 years, and not including those site visits. So it's just simply untenable that we're not able to manage. The second thing, and this is actually the thing that's more kind of the thing that I'm trying to push as much as possible, is our phones. I know you guys are used to calling in, and I know what that feels like. And so while we've increased our phone staff to 5 people now, we on average receive about 34,000 calls a month. And so that's simply, again, and our queue is set up to take in 13 people before then it will simply drop you off or you'll get a busy signal. So it's a poor customer service issue, as well as it's simply, it would be great if this was a small real estate office, but this is actually a large regulatory body, right? And so our goal is actually to stand up a full call center that specializes and is able to provide consumers with information very much detailed and germane to our function, and give them that one-time response which they need. So that would include both the hardware for the call center as well as the staff. And so those are 2 different expenditures that we would be looking at. And so that's also the reason for the additional projections.
Thank you. If you'd like to turn to page 22, there's a graph that just simply shows the difference between the current projected budget and the additional resources that's being requested. And it shows an additional $1.5 million in total cost. And then on page 23, because most of these additional costs are for the educational unit, you can see what that does to the various licenses in the provider fee category. So that first one, the initial approval to operate a nursing program, goes from $5,877 to a little over $12,000. So on a percentage basis, that's a pretty sizable jump, but that's strictly because of increasing that particular work unit. Any comments or questions about that? Page 24, slide 24, shows the impact of these additional costs on individual licensees. And you can see in terms of total revenues for vocational nursing, the revenues with these additional licenses coming from the vocational nurses actually goes down. Now, give me a minute and I'll explain that. On the psychiatric techs, it actually goes down a little bit, but then on the educational nursing side, it actually goes up fairly dramatically. Again, because that's shifting cost away from the individuals to the educational institutions. Now, the reason why the revenues for individual licensees, and the sidebar to that would be that also includes the individual fees themselves, goes down, and that is because there's of all of these allocated costs coming in. So you have a lot of state prorated cost, you have department prorated cost, you have board prorated cost. There's just a lot of overhead support services, and when we increase the cost structure of one piece, it has the effect of bringing more of those overhead costs away from the individual licenses into those, call it the bucket that's where the educational providers hang out. Does that make sense? Okay. Frankly, when I first looked at that, I thought, why is that happening? Until I thought about it for a little bit. Okay, recommended next steps, and again, this is really my recommendation. Number one would be to set fees to recover the full cost. I'm not an advocate for subsidizing fees. I think long-term that gets organizations in trouble. But again, that's just my opinion. And then raise the caps to look at going out like 10 years. The numbers that I have right now is like an annual adjustment of 4.5%. I got that number in consultation with the budget office. You may choose a lower one if you want. I was just with another bureau this morning, and they're actually choosing a lower annual adjustment. And the thought, though, is give yourself some flexibility set your caps going out for 10 years, and then it's easier to change your fees through the regulatory process in incremental years of every 2 or 3 or 4 years as it's appropriate. And then the other thing that I think is healthy is to establish pricing guidelines. For example, in this case, one guideline might be to either subsidize or not subsidize fees for institutions, or create a sense of value, or have a value statement. If an institution incurs costs, then they have to pay for that cost. Individual licensees should pay for their cost and no more. But again, those are policy statements, those are value statements. But one of my standard recommendations is to establish some kind of a sense of policy or value or operating methodology for setting fees based on a good discussion and not just at the whim. So with that, I will conclude my remarks and take any last-minute questions.
Thank you for your presentation. Any board member questions at this time? And once again, to clarify, any action on this item would just be to accept the report, and we would be discussing in November any possible changes to fee schedule. So this is not changing the fee schedule at this time. This is just accepting the report would be the action that we take today. Mr. de Brownstein, did you have a question?
I thought it was your report, and so I'm going to ask. But I thought I saw a fee or mention of schools on probation and assigning a guideline for that. Okay, so it's just in here somewhere. I just can't find it.
Yeah. Where's Cheryl?
Page 16.
Okay.
Yeah, we looked at the cost of a school being on probation is pretty high. It requires a lot of work, and so we actually set up a fee for that.
Okay. And that would be similar to, I want to assign that cost to the school
Yes.
versus if I have a licensee on probation, I
Right.
want to assign that cost
Right,
appropriately
exactly.
to them.
Perfect.
Okay, thank you.
Very good. Couldn't say it better myself. And there is,
Mr. Vertito, did you have a question?
Just want to make sure, clarify, on page 16, you say curriculum revision major, so I'm assuming it's a new school coming with their curriculum, wanting to get approved, and then curriculum revision minors, if they have to do updates, like we're changing the test format or profile, they have to change their curriculum to reflect the changes in the curriculum, so that would be a minor. They take an existing and then they alter it a little bit?
yeah, good question. And for probably a more detailed response, I would leave this up to Cheryl. But yes, basically, I think you're spot on. An application comes in and it's like, halfway through the process, or it's a new school and they have a huge revision to their curriculum versus, just a small minor revision.
The reason I'm asking is on the curriculum revision. We have schools that come and they're not anywhere prepared. And our NECs make a recommendation saying, you need to focus on this, less on this, more hours here. They send it back, and the owner says, you didn't do it correctly, fire the director, hire a new director, and the new director tosses that one and creates a brand new one and resubmits it. Would that be a second billing for a major? Because they're asking to review a new plan.
Right.
Rather than take the one that was reviewed, changes made, and then resubmitted with the changes. Would they get a second, a second bill for major revision since they didn't take the one that was reviewed?
Right.
They're now submitting.
Starting all over again.
Yeah.
Sure. I can't answer that because that's really an internal decision. If it was me, I would say absolutely. Because they just triggered more work. They just triggered a whole nother kind of review all over again. So why should the board, why should individuals pay for the institution who didn't do it right in the first place and now they're coming back with a second one that has to be completely reevaluated. Again, how you do that internally would be up to Dr. Brown and her staff, but that's the way I would do it.
White state actually happens quite a bit, so.
That's what I heard.
Yeah.
Yeah.
So that's why I want to clarify this aspect of it.
Yeah. One of the things that we're doing in discussions with staff, and these projects are very much not about taking a bunch of numbers from the budget office, throwing it into an Excel spreadsheet and shaking it 3 or 4 times, and out comes a bunch of numbers. It's very much about, in this specific example, sitting down 2, 3, 4 times with the leadership of the educational work unit and saying, what's going on? And what's causing you more work? Do you have the right fee schedule in place to reflect the reality of processing, of taking in applications,